Good afternoon. Welcome to Top Gun TV and to the finals of the 10th anniversary of the Baylor Law Top Gun mock trial competition. It has been a fabulous week here at Baylor with a tremendous field of competitors. Part of what makes the Top Gun competition so fun is the way that we introduce the case packet to both the competitors and the judges. We always have a video that gets them off on the right foot with the spirit of the competition. So let's show you what our coaches, our competitors, and our judges see, and this will give you some insight into the Top Gun 10 case packet. Nathaniel, can you roll for us?
What time is this briefing supposed to start anyway?
About 10 minutes ago.
Where is she?
I don't know. You want me to call her cell?
No. That woman scares me. We'll just wait.
Hard to believe it all started with these. Here she comes.
Don't scratch it. Have you told her about Sarah Day?
Waiting on you.
Give them the basics, Rispoli.
This is a products liability case, Sarah Day versus Texera Cycling Company. As you might guess, it's a products liability case about a defective bicycle.
No, it's really about the plaintiff, Sarah Day. She's an accomplished triathlete, and she's also Vice President of Human Resources for Dell Computers in Austin. She came here to Waco Memorial Day weekend of 2016 to compete in the Doris Miller Triathlon.
It's named after the Doris Miller, famous African-American World War II hero. He earned the Navy Cross for his heroism during the attack on Pearl Harbor. The race was a triathlon taking place in Cameron Park. The competitors started at Doris Miller Park, next to Miller's statue, and swam across the Brazos River, and then did the running portion of the race. At the end of the run, Miss Day dashed up Jacob's Ladder, a steep set of steps, and got to the transition area where all the bikes were staged. She hopped off her bike and took off down the sidewalk you see right behind you.
No. Let's go see where it actually happened.
At that point in the race, she came down this sidewalk from the staging area, made a right turn onto University Parks Drive, and was headed down the street to a dirt trail called the Root Canal, which is down the street here. She made this turn, and then there's a factual dispute about what she did. Ms. Day says that she properly stayed within a 6-foot designated bike lane, 6 feet from the right-hand curb. She stayed in that lane all the way down to the Root Canal. On the other hand, Texera says that when she made this corner, she took a wide arc out into the street, so that when she got to the Root Canal, she was not making such a tight turn. And the Texera says she could go faster down into the Root Canal.
The witnesses in this case remember the facts differently. So the plaintiff and her friend Grace Jones say she stayed in the lane, but another competitor, David Whitney, says the plaintiff must have taken the wider arc because she was approaching the root canal from across the road.
When Ms. Day got to the end of University Parks Drive, she came to what's known as the root canal. It's a steep grade dirt bike trail that goes down, curves to the left, and then curves right around to the right. She made this corner, went down the root canal, and then it happened. The next rider found her a few seconds later. She was unconscious off in the weeds to the left. Her bike was further down the trail. The wheel had detached. Ms. Day was paralyzed. The question in this lawsuit is, what caused that? Was it a defective bicycle? Or was it a bicycle rider that was going too fast? So, ladies and gentlemen, that's what this lawsuit is about.
So I say we move on back up to the clubhouse and we talk about the plaintiff's theory of the case and any defenses there might be to that.
This is a fork. This fork connects to the bike and the handlebars go up here and it slides over the wheel. When you slide it over the wheel, imagine that this is the axle that goes through the wheel. It slides right there into the fork and then locks in place with a lever. This is called an open dropout design. It's designed this way so that the wheel can be easily removed, either for transportation or to fix the bike or to fix a flat tire, during a race. Now, the plaintiff's expert, Joe Don Dellinger, says that when on an open fork design, when the axle is properly seated in that U, that it spreads the force of the wheel on the road through the top of that U and is a good load-bearing position. However, he says that when you have hard braking, like Miss Day did during that race, that axle can become unseated. According to Joe Don Dellinger, that is caused by the disc brake, which is part of the open fork design. When the force of that disc brake is applied, it can migrate that axle down. And when that axle becomes unseated and slides down the U of that fork, all the pressure and all the load-bearing force is on just the point of that dropout. When that happens, the fork can break, causing the injury in this case.
Why did the axle unseat and migrate?
So plaintiff's expert says that she applied the brakes twice before she went down the root canal, and that this dislodged it from its seated position. So she braked hard to turn from the sidewalk to the road, and again to turn from the road onto root canal. According to the expert, the axle came unseated from the U of the fork and migrated down at that point. Then she went to the root canal and hit the brakes again. That's when the dropout broke.
Texas product liability law requires that the plaintiff prove that this bicycle was defective. That means it was unreasonably dangerous. Now, part of proving a design defect under Texas law is showing that there was a safer alternative design. There was a way to design that front fork so that this accident couldn't have happened. The plaintiff has a theory on that too.
Now, the plaintiff says that there is a safer alternative design, and that is with this, a closed-end fork. The closed-end fork slides over the wheel, and then the axle, which is bigger and stronger, can slide through the wheel and the closed-end fork, screw into place, and then is locked into place. When that happens, the force of riding that bike is distributed all the way around the axle and into this bigger, more substantial closed-end fork. In addition, this design keeps the brake from being able to move the axle, as the axle can never come out of the correct position. That alternative design is what the plaintiff claims would have prevented this accident from happening.
Now, let's look at it from the defense point of view. Texera's triathlon expert says that a likely explanation for the accident is that the plaintiff entered the root canal just going way too fast. She went airborne, and that the hard landing is what actually caused the fork to break. It didn't break before the crash. He also criticizes the design of the race course and the actions of the operator in marking that bike lane. So the defense perspective comes at it both from the plaintiff acting negligently and the course designer. There have been other Top Gun 10 bike crashes. Texera has implemented some subsequent remedial measures. Now, whether those are admitted into evidence or not is up to you to figure out.
Has the bike been tested?
Well, that's a little bit longer story. The course designer and the operator of this triathlon is an outfit from New York, American Triathlon Association. They run triathlons all over the country, and they actually put them on. And the plaintiff sued ATA along with Texera. Early on in the case, during discovery, ATA moved for production of the bicycle to do some testing. They got it in their custody. They had it stored in a warehouse waiting for their expert to do some looking at it. And then warehouse burned down, destroyed the bike and all its parts. Well, as you might imagine, ATA settled the case pretty quickly. Their carrier paid policy limits. So they're out of the case now, except ATA's negligence will be submitted to the jury anyway as a responsible third party. You see, Texera claims not only that the plaintiff was negligent in going down that root canal too fast, they also claim that ATA was negligent in their design of the race course, in their placement of the cones, in the root canal itself, and Texera claims that ATA was negligent for not having live human beings out there to direct the racers into the proper race course rather than inanimate cones. So the negligence of ATA will be submitted to the jury, along with the negligence of Ms. Day. She was allegedly going too fast.
Now, this case is set for trial tomorrow in the federal district court here in Waco. Now, he and I both have other important things to do instead of handling this little case, so we're going to go attend to those. You can call me when you get a verdict, and I'll have a nice $10,000 bonus check waiting for you after you win. Back up. Toodaloo.
So you're the Top Gun, eh? Ladies and gentlemen, it's time to mount up. Just remember, ain't no points for second place.
Law School and the final round of the Top Gun mock trial competition. This is our 10th anniversary, and folks, I think it's one of our best years ever. We've had a fabulous field of competitors. Some of these rounds have been tight. In fact, one of the semifinal rounds was so tight and went long that it's going to delay the start of our final by just a few minutes. And as always, there's an evil twist that our Professor Jerry Powell, the brains behind Top Gun, has thrown in for the final round. So the competitors will be using their time well. We're so glad you're joining us today for our final, and as you may have noticed, if you've watched the final round in the past, we have a new element. We're going to be having live commentary throughout the trial. And so I want to introduce you first of all to our Top Gun team here at Baylor, and then to our brain trust of mock trial experts from top programs around the country. They'll be joining me here in the studio to tell you their perspectives on what it's like to coach the competition, how it feels in the round, and their perspective on this year's problem. So this is our Top Gun team. Top Gun is the brainchild of Jerry Powell. You probably saw him in the video as the man in white. Robert Little has just joined us as the Director of Advocacy Programs. He's been a long-time stalwart here at the law school, and we couldn't be more pleased that he's joined us full-time now. Professor Jim Wren teaches in our practice court program and co-directs our executive LLM and litigation management. Stephen Rispoli, one of our assistant deans, is always integrally involved in the development of the Top Gun problem and the running of the competition. And I'm Professor Liz Fraley. I teach in the practice court program. I co-direct the executive LLM, and apparently when called on, I wear red and ride bicycles in high heels. So we are so glad you're joining us. I'd like to welcome into our studio right now two of our panelists. Let me introduce you, please. Liz Spencer, come on and join us. Joining me is Professor Elizabeth Liz Lippy. She's the Associate Director of Trial Advocacy at the American University Washington College of Law. Welcome, Liz. We're glad you're here.
Oh, well, I'm happy to be here, Professor Fraley.
And then Spencer Pahlke is Director of Trial Competition Teams at Berkeley Law. Both Spencer and Liz have been here before with competitors. And Spencer, I think you had somebody take home $10,000 one year, didn't you?
Yeah, he didn't share a lot of it, but he did take it home.
Just not feeling the love at all, were they?
I think he said thank you.
Well, that's good. Well, guys, tell us about your perspective on this year's competition and our field of 16 who joined us here. And start, if you want, with your own competitors.
Sure. I was honored to bring Savannah McDonald, an outgoing 3L law student, to this grueling Top Gun competition. I always annually call it the Top Gun torture. I am here, standing here, barely, after having 10 hours of sleep, I believe, in the last 3 days. Does that sound about accurate? But Savannah really did a good job. Unfortunately, she won't be with us this afternoon in the final round, but I couldn't be more proud of her. This year's case packet, as you saw by the video, was a civil case, and frankly, when I first got the file, I thought it was easily digestible until it became 2 a.m. after getting the file and realizing that we still haven't prepared the other side of the case.
A little indigestion from the case file.
Some would say that.
Spencer, how about the Berkeley competitors this year?
Well, so we had Evan Larson as our first chair, and then Nick Cotter as our second chair, and then our coach, Aaron Laycook. I often come along to tournaments like this, and I call myself the mascot. I used to torture myself through this, much like Coach Lippy, but I now come here and basically torture the Baylor people by hanging out and spreading goodwill. So these, our Evan and Nick didn't make it to the final round, but they, as always, loved this tournament. It is really second to none, and they had a great time.
Well, and the fact that their competitors did not make it to the final round was my benefit because it meant I got some really top mock trial coaches who could join me here in the studio. As you could tell in a products liability case, it took a lot of expertise, it took a lot of sponsorship, and so I want to take a moment to thank some of our sponsors who really make mock trial and this Top Gun competition what it is. I've got to start with our friends at the Naaman Howell Law Firm. They're the ones who, in addition to sponsoring our opening dinner for the competitors every year, also, to Spencer's point, hand out the $10,000 check that really makes this competition special. This year, we had some real technical assistance from our friends at Bicycle World. Cody Messerall, who's the CEO of Bicycle World, was really tremendous in loaning us the forks that you'll see as the product defect throughout the trial, loaning us the bike that will be in the final round, and perhaps even more importantly, loaning us Chad Baker, who lent technical expertise to our competitors. Part of what they got to do was book appointments and actually spend time with a real bicycle specialist looking at the fork and looking at how it interacted with the wheel, the brakes, and the assembly system. TrialPad is always a great partner in this. As you know, we use and encourage and give out an award for courtroom technology use, and that's powered by TrialPad. I'm always amazed at how proficient, Liz, our competitors are in using that. How do you prepare them for that?
Well, I wish that there was a good rule to actually go by in order to prepare them. I know that we teach at our school a course on how to use high tech in a courtroom. So you can prepare all you want sometimes, but unfortunately with technology, and perhaps Spencer being from San Francisco can speak better to technology than I can, but you always kind of have to prepare for the worst, if anything, because sometimes it just doesn't work.
Spencer, that's true in real trial, not just mock trial, right?
I was just thinking that, Liz. It really reminds me of my own practice out in San Francisco. We are, a 20 lawyer firm. I wish we had a large tech department. We don't. I mean, the way you learn to use technology is you do it yourself. TrialPad, actually, I will say, is program we use for our own practice, and I like quite a bit. And so that's how our folks learned it. I mean, you just dig in and you do it, and you got to fail a few times, and then you can learn how to make it work.
Well, and part of what makes Top Gun very real world is that we expect the competitors to roll with the punches. If the technology fails, well, guess what? I bet all three of us have had that happen to us really in the courtroom.
Absolutely.
And part of what we're looking for is that poise under pressure that these competitors really bring.
And I have to give a funny story about that. During the fourth round, I was sitting in the hallway with one of the other experts that will be joining you in a little bit, and our teams were competing against each other, and all of a sudden, it's an empty hallway. We see a door open and a timer fly out the door. Somebody in the room had clearly thrown the timer into the hallway because it would not stop beeping. So not just sometimes technology for exhibits don't work, but even things that are as archaic as a timer. But they thought quickly on their feet and chucked that thing out in the hallway. Problem solved.
Thereby avoiding the first sanctions order in Top Gun history, right?
Though almost leading to a personal injury lawsuit, so
Yeah.
sort of balance there.
You know, T-Bone's Barbecue has been one of our sponsors for many years and was actually featured in one of the Top Gun problems, which is always fun. And then our good friends at the Atlanta firm, Gun and Dial, sponsor our Saturday night awards ceremony where we award our professionalism and our technology awards. I'd love your input about the role you think professionalism plays here at the Top Gun tournament.
Should I go for it? Well, so the evening that the tournament starts, the Wednesday evening, is really special for a lot of reasons. All the competitors are there, all the coaches are there, and one thing that everybody at Baylor stresses is that this is a bar association, the Top Gun Bar Association. There's only 32 members of it, and that sort of ethos of realizing this is a small world you're living in has an amazing impact on the competition. I mean, it is really friendly, truly friendly. You're here to actually compete and make friends. And it sort of comes right down the top from Baylor saying that's how it ought to be, and people just wholeheartedly agree.
And I'll echo that, and I'll say that since Spencer only comes down for fun and gets to do his work outside the whole weekends, and I'm in the mix of it, I can add to the fact that before each round, the students here are just extremely professional and courteous of each other. And not only do I attribute it to the fact that most law schools that are here will send their best advocate, not just for advocacy, but also their best advocate as far as professionalism. So that they come into it with a certain level of professionalism, but it's almost like a family, and by the time we all leave here, we've all endured the Top Gun torture. And so there's really no room for error or no room to be rude to each other because we're all in the same boat. And so it's almost as if the student competitors have some kind of simpatico with each other because they all feel bad for each other. So I think that also contributes to the level of professionalism that we see from the advocates here.
Maybe we'll rename it the Misery Loves Company Award for next year.
There could be many names.
You know, I think what impresses me so much about the level of professionalism these competitors, and Liz, you alluded to it, they are working on a raggedy edge. They're so tired. We feed them unless a round gun's long, and then they don't get to eat between rounds. And boy, is that a time when it would be so easy to just bark or snap or complain. And I really have to compliment all of the schools who bring their competitors here.
I'm sorry, I fell asleep. What was that last thing that you just said?
It was probably about the same length as your title at America. That took a while.
I mean, you could just
didn't
call
it?
me the Queen of Advocacy. I told you that.
Well, we'll do that as the round goes on. But anyway, we so appreciate our sponsors. We appreciate the teams that are here. And speaking of which, let's introduce you to some of our panelists. Sarah and Susan and Julia, if you'd join us in studio. For those of you watching, what we'll be doing throughout the day is rotating our panel through so you get the benefit of a lot of different voices. Yeah, go ahead, join us here. Thank you so much. Yeah. Y'all come on in, crowd around the table. We've got plenty of room. Let me introduce you. There you are, Julia Metz, who is the Director of Trial Programs at the Stetson College of Law, a perennial advocacy powerhouse, is joining us. Susan Poles, who's Director of Trial Advocacy at the Loyola Law School in Los Angeles and a professor there as well. And to my right, Sarah Jacobson, who's the Director of Trial Advocacy Programs and an Associate Professor there at Temple. So ladies, thank you for joining us here on camera. Give us your insight about the field this year, who our competitors were.
Listen, I mean, it's the top 16 advocates in the country. The field is always amazing. It doesn't get any better than Top Gun, and no one runs it better than Baylor. So when we talk about the field, it's phenomenal.
Nathaniel, we've heard about the top people. Do we have any images of these 16 competitors who were with us? Is that something we can pull up? This is where we work on the technology, folks. I'm still new to this.
So this is for the people at home looking for the definition of champions. This is what it looks like.
Yeah.
We had a great example yesterday and around, where I wasn't actually in there, but I heard about it later, of both professionalism and technology, where apparently the Cumberland student had a technological error and something didn't go well, and his poor partner was feeling the pressure, and he very kindly said, "No worries." And apparently the judges just loved it because they were working so well together. He cool as a cucumber, didn't let it bother him at all. I think he handled it beautifully.
That's terrific. I love to hear that. So one of the things that happens when everybody arrives is that there is a welcoming dinner. And since we're evil and don't give you the packages until the next morning, the least we can do is feed you and introduce everybody. And that shot you saw of the competitors wearing the sunglasses comes from Top Gun. If you've seen the movie, then you know you gotta wear aviators to be a Top Gun. So we equip everybody from the get-go. Susan, you've had a Top Gun champion, haven't you?
I have not yet actually had a champion.
That's right. Sarah,
Semi-finalist.
you've
but
had- there we go.
We've had two.
That's
Yeah.
right.
Stop bragging. Stop.
We've been really lucky. It was all the kids. It really was. Each of those rounds that we were fortunate enough to win the competition, the kids were amazing. I mean, I was there to help, but it was all them. Sometimes you get special advocates, and they were
Yeah.
special people.
Well, and I suspect that I suspect everyone who's here is a special kid, but you really see them go through the crucible of that pressure and the time constraints with what happens. What was your experience?
It amplifies sometimes the good, sometimes the bad. But a competition like this, where you can't have everything prepared, you can't know everything going in, it really plays to the strength of the advocates who are ready to just go in and try cases. Okay, these are the facts. I know what I'm doing, and I can roll with the punches and really try the round they're in, as opposed to trying something that was all, went the way they thought it was, or perfectly prepared. Because just like real trials, you cannot be perfectly or fully prepared for this. There's just too much to do.
Yeah, it'd really be a different world, wouldn't it, if we could be fully prepared for everything
Yeah.
that might happen in trial?
That would be nice.
Never happens.
Never does. What was your experience like this year, Susan?
We had a fantastic experience. Every round hit, amazing advocates on the other side. And what was really interesting is the creativity that we saw. People picked wildly different theories, and people emphasized different things. It was every round we learned something new about our case and about our opponent's case, and we really, I think we saw top advocacy this year.
Oh,
Well, that's one thing about these files. Always offer alternatives, right, for each side. There are different choices, different theory choices that have to be made. And in that moment, you feel like, if I have the wrong approach, all of this time and effort could be wasted. But no school approaches the case differently, just like in real trials. So the files, even though they're very long to prepare in a short period of time, it's great that they offer those kinds of choices and alternatives, so that people can showcase advocacy and take creative approaches like that.
Absolutely.
And what else is special is they keep adding to the difficulty of the packet. So, day 1 you get one packet. Day 2 it changes. And day 3 it changes even more.
Yeah.
So these students have to constantly be able to adapt and change and be creative and think about what they're doing. I think that's the most fun, but sometimes the most challenging part.
So while Stetson's been coming to this for years, this is the first time I've ever coached it. So when they talk to you about torture, it's a whole new level here. But it is the most professional torture we've ever had. Every round has been filled with qualified judges. Baylor is second to none in the things that they do for these advocates in our schools to make them feel special. But it really does test another layer of these advocates for them to dig down a little deeper, find something else and figure out if they really want to be trial lawyers. But it's a phenomenal experience.
It is well-intentioned torture too, though. We
Valuable
really
torture.
do believe that you should have a sitting district judge, either state or federal, in every round. And we did that this year. It was very important that those people who have worked so hard have a real sitting judge who rules on your objections.
Well, and I always appreciate that Baylor makes a real effort to make sure that there's some diversity of judges in the room. There's nothing worse than coming to a competition and seeing judges all look like the same thing. Our female advocates, our advocates who are kids of color, deserve to see people like them scoring and presiding. And I know Baylor always makes a real effort every year to make sure that the panels kids see are diverse.
We have really talented trial lawyers, and I think all of us feel when we're coaching these young people that the real goal is for them to find their own voice.
Absolutely.
And so you've got to see people who have a voice that might sound like yours in order to really have that resonate. In talking about the creativity of the rounds, we did have some kind of cool things. In addition to the technical expertise offered by the folks at Bicycle World, one of our professors in the mechanical engineering department, and you'll notice in the video it was Joe Dondellinger, and it's actually Joe Dondelinger, his wife informed me, and I'm really sorry for mispronouncing your name after all the kind expertise you gave us. But in addition to helping with the physics and the math in this problem, he actually took a 3D printer and made 8 sets of the product that was at issue. So while this looks like a bicycle fork with that open dropout design, it's really light. It's 3D printed. Stephen Rispolli's father, Frank, then painted them and adhered the warnings with the tiny little label on it. So every student, apparently bicycle forks are very expensive when they're this caliber. And so we were so grateful to Joe Dondelinger for giving us these 3D printed forks to use in the rounds, because let's face it, with a product case, the product itself needs to be front and center.
Absolutely.
Well, and I think every student in every round made use of those.
Yeah,
Right, did a great job using it.
All right, so we started with a field of 16. We went through 4 preliminary rounds, and then this morning we got to the semifinals. And so, Nathaniel, do we have images of our semifinalists? All right, so semifinalist, but you will also see her appearing in the final round, is Tatiana Terry from Campbell Law. She is coached by Dan Tilley. Hannah Wallace is her second chair. Did any of y'all have competitors run into Tatiana?
We did
We did not,
No.
luckily.
Yeah.
That would have been, obviously, by her reputation, that would have been another level of torture, right? Because she is unstoppable. Even her introduction at the welcome ceremony, the things that this young woman has been able to accomplish, it is going to be a phenomenal round in there.
It was good. It was really fun for us. You know, Baylor has its Academy of the Advocate in St. Andrews.
Right.
And Tatiana was there last summer in the Advanced School of the Trial. And let me tell you, I thought she was talented then, and a year has only honed this woman's skills. She is really tremendous. Nathaniel, who else do we have that was in our final round? Sarah, did you run into Craig Shirley?
So we didn't. We ran into the other 2 semifinalists. They were our day one, but neither of the competitors that made it to the final. But again, I think everybody here is at the top of their game. You never get a bad round. I just can't wait to see these 2 fight it out.
Yeah, so Craig Shirley is from the Cumberland Law School. He's coached by Judge Jim Roberts, and we all have loved the name of his second chair, Stephanie Gushlaw. And based on their making it to the finals, we're pretty sure that she was gushing law and technology all the way through. Boy, we had some tight semifinal rounds. So, Nathaniel, do we have our semifinalists? Tell us about these 2 gentlemen.
So this is Kyle from UCLA.
Yeah, Kyle DeCamp.
Kyle DeCamp, and we ran up against him in the 3rd round, and he was fantastic. So professional, so prepared. Just looked like he'd been practicing law for years. It was so impressive.
Yeah.
So I actually ran into Kyle in Philadelphia for AAJ Nationals, and I mean he has just been a phenomenal advocate all year for quite some time. So
Yeah. We should tell you that the pedigree of all of these competitors is just one NCTC, one AAJ, one TOC, one NTC. You know, these are the kids who've been taking home the hardware all year. And then our fourth semifinalist, who ran into...
So
We did not.
we did. It was our first round in the morning. Ran into Akron, and I'm going to butcher his name, so I'm not going to try.
Imakai.
Imakai.
Yeah, we've all been practicing it
Right.
phonetically. I'm just glad we're not jury selecting with him on the panel.
But boy, he was after that round. We thought he was going to take it all. I'm surprised he's not here in the finals, but not at all surprised he made the semis. He's someone who tells a story well. He's genuine. He's comfortable in his own skin. Took real advantage of the opportunities that came up in the round. Was good at trying the round that he was in, as opposed to like maybe what they prepared for, and just so much charisma. He's great.
He'll be
a
imagine he's
wonderful
too
tough.
well. So
I
he's got a whole
know.
other
Yeah.
year of doing this next year, so he's a force that's going to be
that's a
reckoned
problem.
with.
Yes, I know.
We'll be
That's
seeing
a
him
problem.
again.
Yeah.
Here's what we figured out his Achilles heel is. He was forced to share his nickname of Princess. And that's the real reason, Imakai, that we don't say your name well, because in our names and hearts, you will always be Princess
No,
to
you put
us.
it out there on
Together
national
all at once.
television.
I
Yeah.
am, because let me
Princess.
tell you, anybody who is that good a lawyer, I think has the ability to withstand that nickname. So, yeah, I mean, I thought those semifinal rounds were tough.
Amazing.
I was not sure that they were going to. I mean, I was glad it was not in their judging. So, all right. So we have got a really impressive panel of judges for the final round, and I want to spend a little time talking about them, and I'm going to kick it to y'all because this year we have mixed practicing trial lawyers and judges with former Top Gun champions.
Oh wow.
So our presiding judge for this round will be Judge Barbara Lynn. She is a sitting federal district judge for the Northern District of Texas. She was the first female judge to be appointed to that bench. She is the chief judge of the Northern District of Texas, and actually I misspoke, she was the first woman to hold that position of chief judge. Before she took the bench, she was a fellow of the American College of Trial Lawyers, had a phenomenal trial practice. Roy Barrett is a partner at Naaman House Smith & Lee, so in addition to giving us $10,000, they gave us one of their talented trial lawyers to be one of our judges for the final round. Like Judge Lynn, Roy is a fellow of the American College of Trial Lawyers, and you're going to hear that repeated over and over again because every practicing judge or lawyer who is judging this round is a fellow of the American College of Trial Lawyers, so they know a little bit about trying lawsuits. We have also got Jerry Clements. She is the chair emeritus at Lock Lord LLP, ran the whole shebang for many years. She's a Baylor lawyer. She's a talented trial lawyer. She too is a fellow of the American College, which is terrific. And then we have got Mark Mann, who, in addition to being a fellow, is just a tremendous trial lawyer, has tons of experience trying intellectual property cases in the Eastern District of Texas, and we're just thrilled to bits that he's back. We have got 3 former Top Guns. We actually had a 4th one here, Jacob Morse, who won, but he can't be in our studio because one of his colleagues from his law school is competing.
Absolutely.
So
Tatiana, yeah.
we thought we'd better keep this going. Sarah Chervinsky, who went to Yale, graduated in 2011, was one of our early Top Guns. Colin Tierney was one of Spencer's candidates, and then we've got Ben Wallace as well. So it's really fun. What do you think it'll be like for those Top Gun winners to be back judging?
I think it's going to be fun for them. You know, the intensity of Top Gun is something that you always remember. But if you're a Top Gun winner, of course, this must have been winning this competition would be a very special moment for them. And to get to come back here where that all happened And I mean, you can't get better, more perfect people to
Jacob,
watch.
Jacob said that
Yeah.
courtroom looks a lot smaller now than it did the day he walked in to try the Top Gun final round, and I bet he did. So we'll be with you throughout the broadcast. Of course, the focus is on the trial because that's what this is really about. But our experts will be adding some insight as we go through. We can see through the studio that our panel of judges is lined up and ready to be knocked in. And so we're going to turn you over to the Top Gun final round broadcast.
Let's get ready to rumble.
I didn't know this was on. Next time.
I'm live. I think so.
This thing is loud.
Afternoon, everybody. Welcome to Top Gun 10. My name is Jerry Powell from Baylor Law School, and it's my pleasure to welcome you all to the 10th anniversary edition of the Top Gun National Invitational Mock Trial Competition. Our judge and jurors have not yet come in, but I would like for everyone here in the courtroom audience as well as on the internet to meet the very fine young lawyers who are competing in the competition today. On behalf of the plaintiff, representing the plaintiff in today's case, Ms. Tatiana Terry from the Campbell University Norman Adrian Wiggins School of Law. Ms. Terry's second chair is Hannah Wallace, and her coach is Mr. Dan Tilley. Representing the defendant today is Mr. Craig Shirley from Samford University Cumberland School of Law. Mr. Shirley's second chair is Stephanie Gushlaw, and his coach is Judge Jim Roberts. We will be beginning the trial momentarily. The Marshal Service has requested that I remind everybody to turn your cell phones onto silent, please, and we'll proceed.
The Western District of Texas Waco Division is now in session. The Honorable Barbara Lynn presiding.
Please remain standing for the jury. Be seated, please. Court calls the case of Day versus Texera Cycling Corporation. I understand there may be some pretrial matters for the court to take up. Ladies and gentlemen of the jury, I am deeming you not to be present during the pretrial. We will get back to you when we begin with the trial proceedings. Are there any pretrial matters, counsel?
Yes, Your Honor.
All right.
Your Honor, just by way of notice of appearance, my name is Tatiana Terry, and together with my co-counsel Hannah Wallace, we proudly represent Ms. Sarah Day in this matter. Your Honor, I do have notices of appearance. If you would like, I can approach the bench.
No, it's not necessary.
Okay. Your Honor, we just have one substantive matter.
All right, let me hear who defense counsel is before.
Good afternoon, Your Honor. My name is Craig Shirley. I'm here alongside my co-counsel, Ms. Stephanie Gushlaw, and we're here on behalf of the defendant, Texara Cycling Corporation.
All right, thank you. All right, Ms. Terry.
Yes, Your Honor. We would like to make a motion to exclude testimony from Mr. Michael Durr. By way of brief background, we have a good faith basis to believe opposing counsel will offer this testimony. But, Your Honor, you'll see that Mr. Durr is not qualified under the Rules of Evidence 702.
Well, just a moment. Are you planning to offer Mr. Durr?
We are not, Your Honor.
Okay.
And
You win.
Your Honor, that concludes our substantive matters. We're ready to proceed.
All right, thank you. Do you have any pretrial matters?
Yes, Your Honor. We just have a little housekeeping matter. Per the court's pretrial order, there's a pretty extensive list of exhibits that have been pre-admitted into evidence. We would just ask if it would be all right with the court if we freely publish those exhibits, or if Your Honor would like us to ask each time for permission to publish.
No, all exhibits that are in paragraph 2B of the pretrial order are pre-admitted and may be used for all purposes.
Thank you, Your Honor. With that, the defense is ready to proceed to trial.
All right, thank you. All right, thank you very much. You may call your first witness.
Your Honor, could I do an opening statement if that's all right?
Oh, yes, that would be a good idea, too. All right, thank you. You may make your opening statement. Do you wish to reserve your opening statement?
No, Your Honor. We'll be giving an open
All
statement.
right, thank you.
May it please the court?
All right, ladies and gentlemen of the jury, you're back. This is plaintiff's counsel, and she will be making her opening statement.
When a corporation rushes a product onto the market and fails to ensure that it's safe, they are responsible if their consumers get hurt. And that makes sense because they make the product. If they fail to test it, fail to give adequate warnings, if they just rush it onto the market, they effectively make human beings test dummies. That's what this case is about today. It's May 2013. And in 2013, Texara Cycling is starting their company. See, they've inherited that company from a smaller biking operation. And they've hired Jamie Patterson. Jamie Patterson is supposed to make Texara the biggest, baddest bicycling company in America. And to do that, she has to make them some money. So Jamie Patterson is sitting in the boardroom. She's pondering, she's brainstorming, how can I make Texara Cycling the biggest, baddest bicycling company? Instantly it comes to her. Change the brakes on the bike. Change the rim brakes that aren't on the axle, that are safer, and make them disc brakes because consumers love them. So that's what they do. They take their Top Gun 10 bike and they put disc brakes on it. They don't test it. They didn't test it when they got it the first time. They just put it on the market and let people buy it. That's what happens, members of the jury. People buy it. Sarah Day bought their bike. Little did she know, she bought a bike that had never been tested, had one teensy-tiny little warning on it that was inadequate. She bought a bike that was going to fail, and she never knew. Now, today we have brought 3 claims. 3 claims: design defect, marketing defect, and negligence. We have the burden with those claims. We have to prove them to you by a preponderance of the evidence. More likely than not, that Texara Cycling had an unreasonably dangerous product. A safer alternative design existed. That they just put it on the market, knowing it was dangerous. Failed to give adequate safety instructions or warnings about it. They acted unreasonably as a bike manufacturer. And she was injured because of it. Now I want to take a minute. I want to introduce you to Sarah Day. This is Sarah Day. She's a wife, a mother. She once was a tremendous triathlete.
So we're in the We're in the middle of the plaintiff's
But on May
opening
30th,
right
2016,
now. Liz,
she
are
got
you
on that
picking up
bike.
any clear themes from
And
Tatiana?
she rode that bike.
Absolutely. As we
anybody
all
else
heard,
would.
she talked about
Just
how
press the
the
brakes. Her
consumers
life
are actually the
changed
crash
forever.
test dummies, so to speak. I anticipate
You're
that
gonna
that's
hear
going to be
from Miss
something
Day
that's brought up repeatedly from the
She's gonna
plaintiff's
talk
case.
to you
I
about
will
how
say
she
one of
rode
the
that
most
bike
unique things
like
about the
anybody
Top Gun
else would.
competition is the
That all
use
she
of
did
real
was press the
exhibits.
brakes.
I cannot help but keep looking at that
She's gonna tell
bicycle
you that
that's
she
in the
had
room.
no
I don't understand why
idea
they would let
what
it
was
be there.
waiting
Yeah,
for her.
interesting.
She had no
too picked
idea
up the
what was
crash test
happening
dummies.
up under
I
her.
like how that's an aggressive move.
She thought
I
she
feel
had a
like
safe
it's
product
a little
because they made her
quick
think it was a
to be using
safe
crash test dummies right off the bat with the jury who doesn't yet know
Then we're
us,
gonna
but
call
she's a wonderful advocate. She's going to make
Professor
it
Don
work.
Dellinger.
She is, and you know, some of what
Professor
you're
Don
hearing is her
Dellinger
voice.
is going to tell you
She's
all
pretty
about the engineering of the
argumentative.
bike.
She's pushing that edge, but she's
What
not
are disc
drawing an
brakes?
objection.
What are rim brakes?
So, you
What's the
know, if
difference
they're not
between an
objecting,
open
you can
and
keep
closed
it going,
fork?
right?
Well, and I view it almost as
I want you to
rightfully
see that right
passionate
now.
on
So
behalf
when he's
of her
testifying,
clients. We
he can
came in
really
at the
put an
time that she was
image to
introducing
words.
the plaintiff, Miss Day, as you can see, is in a wheelchair. I think she has every right to be indignant and passionate.
Yeah. All right. Now we're using some of the exhibits.
This is an open fork. As you can see, it points straight toward the bottom in a U shape, upside down U. That's what was on her bike. That bike.
And there you have it.
And
She
with this
referenced
U
the bike,
shape,
so
you'll
we were
see
all
that it's
questioning why it's in a
open at the
courtroom. She
bottom,
just
so
used
something can come
used it as a
out of
prop.
it.
Although I will say, maybe from the plaintiff's
Alternatively,
perspective,
Professor Don
you
Dellinger
want
is
the
going to
jury's
talk to you
eyes to be on
about
the
closed
wheelchair,
fork design.
not on the bike. And so I think maybe unveiling
With this design,
that
you'll
bike
see
later
it is a
during
complete
testimony may have been kind of a
360
cool way to
circle.
introduce
It's
it during the
enclosed.
trial.
Here's where the
Nothing is gonna
plaintiff's
come
side
out.
attorney jumps out.
He's gonna tell
being a
you.
plaintiff's attorney, I mean, I want the focus on
He's
that
going to
bike.
tell you
I
that
want it
this
on the defendant
design
all day
was
long.
readily
minds will
available to them
disagree.
and they chose
Well, I
not
didn't
to
say
put
it was
it on
reasonable,
top.
but
He's going to tell you all they
I
had
want
to
to think about what the
do
defendant did or
was
didn't
go
do.
from this
Well, and another
to
thing
this.
to think about. This is the first time they've had the actual bike in the
So
courtroom.
maybe they didn't actually think it through.
They're having to adapt. They may not have even thought about moving it.
Well, and I understand that Top Gun informed the coaches before the final round
And then
that
members
they're
of
no
the
longer
jury.
allowed to coach. Is that
We
accurate?
anticipate.
Well,
They're gonna
we'll
call
talk
some
about
names.
that
All
at the
right.
break.
Well,
There
we
was
didn't mean to
They'll
tease
call
or give away any
Jamie Patterson.
surprises.
We love a
The
good
chief
tease.
operating officer of Texera Cycling. She's going to have to admit some things to you. She's going to have to admit that they didn't test that bike the first or second time. She's going to have to admit that they decided to put this bike into the market without ensuring that it was safe. And when she admits those things to you, it'll lead you to one conclusion. Now, after you've heard all of the evidence today, I'm going to have one more chance to come back and talk to you. When I do, I want to walk through all of the evidence that you've heard so that when you come back with your verdict, you have no hesitation in telling them they just can't do this. I am confident that you'll agree. When a corporation rushes a product onto the market and fails to make sure that it is safe, they are responsible if their consumers get hurt because they made them test dummies. Thank you.
Thank you, counsel. Mr. Shirley.
We left it in its
You know, the plaintiff is right. This case is about a dangerous design defect. It's about a dangerous design defect in the bike portion of the triathlon that the American Triathlon Association put together. It's not about the design defect of Texera's Top Gun 10 bike, because there was no defect in the bike. And look, this
And
is
every
a
time they
difficult
say it, I
case.
think
Nobody
of
likes to
American
stand up
University,
here,
just so you know.
knowing
It's not all
what Miss
about
Day
you.
is
It's always
knowing the loss that she suffered.
Princess isn't here anymore.
Our hearts go out to Miss Day because I genuinely could not begin to understand how bad that must hurt to lose something you love. And I understand looking for someone to blame, but that blame does not lie with Texera Cycling Corporation.
But that came out to me
It
pretty
lies at the
ingenuine.
feet
It's
of
a
the
difficult
American
line to
Triathlon
walk there.
Association because
And I
they
think one of
failed
Craig's
to
strengths
protect their
is the
competitors
ability to
by
seem
designing a
genuine,
dangerous
so to
bike
speak.
path
And I will say,
leading
coming
down
out
a
the gate
dark
and making
dirt
concessions from the
trail.
defense, particularly in this case,
It's a pretty smart strategy.
It's 5:45 a.m. on May 30th, 2016.
For those of you who
Miss Day arrives at the
remember,
event
Craig was a
with her
competitor
friends Grace
last
Jones and
year,
David
and
Wheat.
he won the professionalism award.
They start going
So
through
I
the
think
pre-race
that
rituals
really
like
nice
they've
demeanor
done
is just part and
at every
parcel
other
of who
triathlon.
Craig is.
I think he's
They start
kind
loading
of
up on
given away this
protein and
name.
carbs,
Yeah, it has a few more
stretching,
zeros behind it.
exercising, meditating, reading, the same thing they've always done. And then they all get their bikes, their equipment, and they take them over to the bike portion, the bike staging area.
Interesting,
By now
but
it's
he
8
chose to step a little bit
And
back
all the
from
racers
what
are lined up
Tatiana
at the
delivered
starting
for our opening
line of this
statement.
race, anxious to
Craig
get the race
is a
underway.
tall, burly man.
Miss
and I
Day
think
jumps
that
into
may
the
have
river
been
and
a
starts the
deliberate
first leg
decision on his
of
part
the
so that he
triathlon.
doesn't overwhelm
The swimming
jury in
portion.
opening statement.
The 1,500
Yeah, it'll be
meter
interesting to
swim.
see if he moves closer for closing
Miss
argument.
Day is swimming right
He closes
alongside
that gap
her
once he's got
triathlon
more
partner, Grace
credibility.
Jones. And Miss Day and Miss Jones are making pretty good headway. They're starting to separate themselves from the pack. In fact, when Miss Day gets to the other side of the river, she sprints up the bank and starts the second leg of the race, her favorite part, the running portion. She runs through Cameron Park, up Jacob's Ladder, to the biking staging area. You see, well, when Miss Day got into that biking staging area, she was the only one there. That's how far in front of everybody else she was. There were no other competitors. Well, now I say that nobody else was there. The ATA, the American Triathlon Association, they did have some volunteers at the bike staging area, which is where the bikers put on their shoes and climb on their bikes. They made sure they had volunteers there. So Miss Day, she reaches down, she grabs the Top Gun 10. She hops on and she starts pedaling. Down the sidewalk, taking a right onto University, heading downhill to the root canal entrance. Now you're going to learn that when Miss Day turns on University, there's no cones outlining the bike lane. Nothing preventing the riders from swinging a wider arc to gain more speed. There's no metal barricades. There's no volunteers there. There's no traffic cones preventing riders to do that. So you're going to learn that Miss Day, she took a wider arc so she could gain speed and then enter the root canal trailhead head on. And when she did that, she goes up the ramp to the entrance of the root canal and starts coming down on the back side downhill. And unfortunately, that is where Miss Day had her accident. And we're here today because the plaintiff is suing Texera Cycling Corporation, claiming that they had a defective design in their bike that caused her injuries, claiming that we failed to use ordinary care, and that's what caused her injuries. But Texera Cycling Corporation is not just some big company. It's made up of people just like Jamie Patterson, who are striving to make the best and safest bike that they can. And I want to introduce you to Ms. Patterson. This is Jamie Patterson. She's originally from San Diego, California, and moved to San Francisco with her husband and her 2 kids. Ms. Patterson is the Chief Operating Officer at Texera. She graduated from UC Berkeley with a master's degree in engineering. Texera is made up of people just like Jamie Patterson, striving to provide their customers with the best and safest bike that they can. Now, throughout trial today, you're going to hear a lot of technical and engineering terms, but what this case really boils down to is the plaintiff's claims that Texera had a defective design. Now, on top of claiming that there was a defective design, they're also claiming that there was a marketing defect and that we failed to use that ordinary care. So I want to walk through each one of those claims because the judge is going to tell you that the plaintiff has to prove those. In order to prove that there was a defective design, the plaintiff has to prove, first, that the defective design was unreasonably dangerous. Second, that there was a safer alternative available to Texera. And third, that the defective design, if any, was a producing cause to Ms. Day's injuries. But you're not going to hear any evidence today that this was an unreasonably dangerous design. This was a strong fork design. It had a lever that clamped on the axle to that open fork. This was a reasonably safe design. But the plaintiff also has to prove to you that there was a marketing defect. And the judge is going to give you a list of elements that they have to walk you through to prove that marketing defect. But I really just want to spend time on one. Because as I told you earlier, what this case boils down to is that defective design. Because this was a reasonably safe product. To prove their marketing defect claim, they have to show you that there was a failure to warn and that the failure to warn made the product unreasonably dangerous. You're going to see warning after warning after warning throughout trial today. In fact, Texera has the warning stamped on the fork on the bicycle. They have a warning in the owner's manual that's given to every customer. They're not going to be able to prove their marketing defect claim because there was a warning. But also they have to prove that Texera was negligent, which means they have to show that we did not act as an ordinary bike manufacturer would have in the same situation. Texera exercised ordinary care. The owner of Texera bought the company, the previous company, Nexus. Nexus was the original designer of the Top Gun 10 bike. Ms. Texera took the disc brake design and switched it out on that Nexus Top Gun 10. That was the only change to that bicycle. And then they just continued selling it. All they did was take a disc brake and attach it to the bike. They exercised ordinary care in relying on the previous company's testing that was done. They exercised ordinary care. But not only will the plaintiff fail to prove her three claims, but we expect the evidence is actually going to show you, and we expect to prove to you, that a little bit of the blame has to lie on Miss Day. As hard as it is to stand up here and say that, that's just the truth. It's the hard truth. You're going to learn that Miss Day removed the wheel of that front bike over and over and over again using the quick release system. She's going to tell you that she did it hundreds of times. And those hundreds of times that she did that, she never had a problem. But Miss Day's going to tell you that on May 30th, 2016, she just can't specifically remember tightening that clamp all the way down. That's the only time she can't specifically remember doing that. And it's the only time she had her accident. But there may be evidence that Miss Day was going upwards of 20 miles an hour when she'd made that sharp right turn and hit that root canal trailhead. We're going to show you that some of the blame has to lie there. But most importantly, the most blame has to lie with the American Triathlon Association. You do not just get to design a course any way you want, step back, and not accept any responsibility. You owe it to your competitors. You owe a duty to your competitors to keep them safe, to provide them with warnings of the dangerous parts of your design. You're going to see that on University Park, like I've already said, there were no cones. There were no barricades. There were no volunteers there. That in itself is not what's unreasonable. It's the fact that immediately following that straightaway is a sharp, dead right turn leading down a trailhead. And we're going to show you how dangerous that trailhead is. This screen right here is showing you what you're looking at standing on University down the trailhead. You're going to learn that there's a pile of rocks in the middle of that trailhead. You're going to learn that no one from ATA spray painted those rocks red, put stakes around the rocks, put a flashing sign around the rocks, did anything to protect their riders from running slam over those rocks. Nothing. They didn't have volunteers at the trailhead. They didn't have volunteers on University. They didn't have anybody warning their competitors that they were about to enter this dangerous trailhead. That failure to warn is what caused Miss Day's injuries. The ATA doesn't just get to walk away after they force their competitors to go down this dirt trail with no warning, with no safety measures. That's why the blame has to lie with them. And that's what the evidence is going to show. The evidence will show that that is the dangerous design defect, not the Top Gun 10. Texera is not responsible for Ms. Day's injuries. Find them not liable. Thank you.
Thank you, counsel. All right, Ms. Terry, now you may call your first witness.
Your Honor, at this time, the plaintiff calls Jamie Patterson to the stand.
Ms. Patterson, raise your right hand, please. Do you solemnly swear or affirm that all the testimony you're about to give in the matter now before the court will be the truth, whole truth, and nothing but the truth? All right, thank you. Be seated.
Ms. Patterson, you work for Texera Cycling.
Yes, I do.
You're the COO.
I am.
You became the COO because Nick Texera wanted you to make his company great.
I would hope so, yes.
Wanted you to become the biggest, best bike manufacturer.
Yes.
He offered you big money to help him do that.
He offered me a appealing compensation package, if that's what you mean.
Yeah, but in your words, an offer you couldn't refuse.
It was a very good offer.
So you joined them and began an aggressive approach.
I joined them because the company wanted to grow in an aggressive manner.
Right, an aggressive approach to become the best bike company in America.
Well, not only the best, but the premier bike company in America.
And that corporate strategy was built on growth.
I suppose you could say that.
Growth for a corporation means sales.
Well, any corporation to be successful needs to be able to sell their products.
Let's talk about how you made that growth with sales happen. You already had an existing bike design that you took, right?
I'm sorry, could you clarify that?
When you got to the company, you took an existing bike design, correct?
When I joined Texera, are you talking about when Mr. Texera bought the company from Nexus?
Yes, you took that existing bike design, right?
We took the design that Nexus, the bicycle corporation, had developed for a bicycle that it called the Top Gun 10. And when Mr. Texera purchased the company, we renamed it the Texera Top Gun 10.
After you renamed it, you began to look at market studies.
Of course, we're always looking at market studies.
To focus on what would sell.
That's right.
You wanted to put something out that would be popular.
We wanted to put out the best and premier products in line with our mission.
So it would be popular and sell.
The goal of most corporations is to sell their products.
So that's a yes?
Yes, I suppose.
You put this bike out and you called it affordable.
Yes.
Convenient.
Yes.
But you didn't say it was safe, did you?
Now, when you say we didn't say it was safe, do you mean in a particular context?
I mean specifically, when you were considering that bike, you thought about affordability and convenience, but your main concern at that time wasn't is it safe?
I would not say that, no.
Okay, well, let's say you did think it was safe. You didn't run a test on the bike, did you?
The Nexus Corporation had already extensively tested the safety, the safe use of the bike, and it had passed.
You don't actually know that to be true, do you, Ms. Patterson?
I'm sorry, I don't understand your question.
You don't know that to be true, do you? You didn't work for Nexus.
No, I did not work for Nexus.
So you don't know what Nexus did?
I know that Nexus told the Texera Corporation that it had run safety tests.
Right, they told them, so that means you don't know that it happened.
If you're asking me, was I there? I was not there.
Okay. Now I want to talk to you about your role specifically at Texera Cycling. Could you agree with me, Ms. Patterson, that with great power comes great responsibility?
That
is an axiom, some might say a cliche.
You'd agree that it's true, right?
I think I'm going to abstain from wholeheartedly agreeing with that.
That's fine. You were the COO.
I am.
You oversaw the entire company.
I oversaw the operations part of the company.
Yeah, the design team, they reported to you.
Yes, they did.
Engineering, you.
Yes.
Research and development, you.
Yes.
Marketing and sales, you.
The operations of the company.
Right. When a bike hits the stores, it's design, manufacturing, and marketing. That's all on your shoulders.
I do oversee those functions for the company.
Thank you. Let's turn and talk about how you handle those functions in the company. You discussed that you changed the brakes.
Yes.
You decided to change the brakes and to put them at the axle of the bike.
We changed from what is called a rim brake to a mechanical disc brake, yes.
When you made that change, you didn't test it, did you?
We did not, because it was not necessary according to industry standards.
You didn't think it was necessary to test a product before you put it on the market?
The product had been tested. All we did not affect the design at all. All that happened was one part was replaced in favor of another.
Ms. Patterson, I'm going to point you back to my question. You changed the brakes on the bike, but you didn't think it was necessary to test the brakes on that with the bike?
According to industry standards, no, it was not necessary.
And you're testifying today that it's normal in the industry not to test a change that you make in a bike design.
I'm saying that it was not necessary, according to industry standards, to retest the bike based on the change that we made.
So you just put it on the shelves?
We sold the bike, yes.
And you did that because you felt like it would work?
What would work?
You felt like it would work to change the bikes, correct? That was your feeling.
I'm sorry, I don't know what you mean by it would work.
I'm sorry, I'm using your words, Ms. Patterson. In fact, you felt like it would work to change the brakes, correct?
We changed the brakes to improve our product, to improve the bike for our consumers who we care about very, very deeply.
And you never tested that theory to see if it would be safe? That's a yes or no. You never tested it to see if it would be safe?
Texera did not test the bike.
Thank you. I want to shift and talk about what your attorney said during his opening statement. Now, you think this is a safe bike?
Yes.
One of the safest in the industry?
It is a safe bike.
You think it's as safe as it could be?
It is a safe bike.
You think it's one of the best bikes?
We are very proud of our product.
But you know that bike has had some issues, hasn't it?
I don't know what you mean by issues.
I would love to point your attention to it. In mid-2015, another consumer's fork fell out of their bike. That's right?
If I am correct as to what you are talking about, that happened when the consumer ran the bike into a concrete curb.
The fork fell out of the bike, yes or no?
After they ran into the concrete curb full force, yes, there was damage to the bike.
And there was another incident in early 2016. Yes?
Yes.
There, the front fork broke on that bike as well.
Are you referring to Mr. Albright?
I'm referring to what you know. The front fork broke on a bike in 2016 that was the Top Gun 10, correct?
I'm not sure what incident you are referring to.
Well, I'll point your attention. You mentioned Mr. Albright, right?
Yes.
And now you know about that incident involving him.
Yes.
The front fork.
Objection, Your Honor. May we move outside the presence?
Yes, ladies and gentlemen, you're deemed to retire to the jury room.
Now, this line of questioning is referring to a 2017 settlement agreement between Mr. Albright and Texera. Because this happened after Ms. Day's accident, not only is it irrelevant because it doesn't go to show any notice or anything like that, it's extremely prejudicial because it would only be used to inflame the jury against Ms. Patterson.
Well, testimony has been going on now for about 60 seconds with no objection.
Yes, Your Honor, but this particular line of questioning just transitioned into the accident that happened after Ms. Day's accident.
Well, is this not the incident that occurred in 2016? I thought that's what you said, Counsel.
That is what I asked about, Your Honor, early
2016.
However, Your Honor, she started mentioning Mr. Albright. Mr. William Albright settled his claim in 2017. That's when the accident happened.
Your Honor.
Those are two totally different accidents.
Your Honor, I was just parroting what the witness said. To get back to 2016, she opened the door in 2017 with Mr. Albright.
Right, well, we're not going to talk about 2017.
Yes, Your
I
Honor.
think there's some confusion about whether Mr. Albright is 2016 or 2017. So 2017 is excluded, 2016, you may develop that. If you need to correct the witness that that's not Mr. Albright, you may.
Your
Objection
Honor.
sustained in part.
Now, Ms. Patterson, there was an incident in 2016, right?
Would you let me know which incident you are referring to?
Sure, one of your consumers, their front fork on their bike broke off while they were riding it, right?
And I believe that's when I discussed that the consumer ran the bike into a concrete curb.
Oh, no, that was 2015. I'm sure you're getting confused. This was another person whose bike was damaged, right? Yes?
Can you provide me with more details?
Sure, in early 2016, the crown of one of your consumers' front fork broke, right? You know
Objection,
that.
Your Honor. May we move outside the presence?
Yes, same instruction, ladies and gentlemen. Yes, sir.
As the opposing counsel just pointed out, this particular lawsuit has to do with the crown of the fork. And here today we are talking about whether the open fork design itself, the bottom part of that fork, is defective. This lawsuit that happened in 2016 dealing with the crown breaking is not substantially similar enough to be relevant.
Okay, well, we've been talking about 2016 for quite some time. If I exclude that now, the jury is going to have no idea how that issue is resolved. So if the only incident in 2016 involves a portion of the bike that you claim to be irrelevant, I don't know why there wasn't an objection earlier. Let's just cut to the chase here. I'm excluding 2017 involving Mr. Albright. Whatever happened in 2016, questions have been asked without objection, and I'm going to permit the issue to be finished. Objection overruled.
Just to finish this issue about 2016, you do know that a consumer's front fork broke in early 2016.
Yes,
Thank
that
you.
dealt with the crown of the fork.
Thank you. Now I want to ask about Ms. Day's injury. The two incidents that we just discussed, those were well before Ms. Day had her incident.
They happened in 2015, and Ms. Day's accident occurred in 2016.
So concerns were being made to you then.
These incidents happened in 2015.
When these incidents happened, Texera never issued a recall,
No, we did not.
never issued a warning.
A warning, we have many warnings. What type of warning do you refer to?
You didn't issue a warning that two customers that just told you their front fork broke. You didn't tell anyone that, did you? Yes or no?
No, we did not issue a news release that two forks had broken in 2015.
You didn't say anything about it. Yes or no? You didn't tell anyone anything about it.
Well, no. If you were saying, did we release it to the media? No.
I want to turn and talk to you about another bike that you make at Texera Cycling.
Okay.
You make a bike called the Top Gun 12.
We do.
And you think the 12 is different from the 10.
The Top Gun 12 is a different bike from the Top Gun 10.
Isn't it true it's almost identical to the Top Gun 10?
Well, if it was identical, we wouldn't have given it a new name. It is actually a more, as every manufacturer does, we improve our product and we put it out to the market, and we believe the Top Gun 12 is the next step, if you will, with respect to the Top Gun model.
I'm so glad you just said improve your product. Let's talk about how you improved it. Now,
Objection, Your Honor. May we move outside the presence?
Yes, you're deemed excluded, ladies and gentlemen. Yes, sir.
Your Honor, this is a subsequent remedial measure the plaintiff is going into. Ms. Patterson was talking about how they have two different bikes, the Top Gun 10 and the Top Gun 12. The Top Gun 12, they put a closed-ended fork design on that Fine.
Again,
That is a
let's talk
subsequent
about the
remedial measure
timeliness of
with
this
this line of questioning.
objection.
It will only be used to
Absolutely.
show
I
that
think
they were
these are,
negligent.
again, another
It's not being
example of
used to
things
show
that
that
should have
that
all handled
alternative
in
or
motion and
that safer
lemonade,
design
starting
was
with the
feasible
2015
or
incident, the
economically
different sections of the
attainable.
Fork
Your Honor,
incident,
briefly respond?
and now the Top Gun 12.
Your Honor, it's been
Susan?
stipulated
Yeah,
by
I
the parties
agree.
the
Judges
Top
were
Gun
willing
12
to
was
keep this
created
out in
January
several rounds.
26,
And I think letting it
2016.
go this far
Ms. Day's
really
accident
can hurt
was
the
May
defense.
30,
Right, it got messy in
2016.
here,
So
and
unless Ms.
especially if
Patterson is
you know
clairvoyant,
that they're
it
going
can't be a
to, the other
subsequent
side's going to
measure
call your
because it
witness as a
happened
hostile
before.
witness, and this is
Your Honor,
the
the
first
cell, the
impression
manufacturing,
that
and
the jury
the line
gets
of question
of
was leading into
your
the
client
subsequent
and
remedial
of
measure
you.
of
The stuff
continuing
you
to
can
sell
clean
that
up, the
bike.
bad
And
stuff you can
what
clean up in advance,
Texera
or at
did
least
was
know
when they
where the
continued to sell the
edges
Top Gun
are
12,
through
they
the pretrial motions.
discontinued
Okay,
Top Gun
let's go
10.
back and see what
Well,
Tatiana's
I'm
doing.
not going to allow evidence of discontinuing the Top Gun 10. That is a subsequent remedial measure. But if the Top Gun 12 was created before the accident, that's not a subsequent remedial
Right,
measure.
Your Honor, I was not clear in my original objection. That's what I was objecting to. This line of questioning was going into that subsequent remedial measure of discontinuing the 10.
Okay,
I was
you
just
can't
letting the court
develop
on that.
that.
Your Honor, yeah, I appreciate that he wanted to
Right.
read my mind, but that wasn't going to happen.
Okay, well, I'm going to make sure I don't have to read your mind. The discontinuance of the Top Gun 10 is not a proper subject. That's a subsequent remedial measure. The development of the Top Gun 12 may be the subject of evidence. Thank you.
Yes, Your Honor.
Back to what we were talking about, Ms. Patterson. You said you had improved the design. You made the Top Gun 12 January of 2016.
Yes, and to clarify, I would say that the Top Gun 12 is the next generation of the Top Gun bicycle model.
Well, let's compare the two editions that you think are different. They have the same frame, don't they?
Yes, they do.
Same handlebars,
Yes, they
same
do.
seat,
Yes, they do.
same tires,
Yes.
same disc brakes.
Yes,
In fact, the only difference is that the 12 has a closed fork.
that's correct.
Now, finally, I'd like to talk with you about how you advertised your product. Your Honor, may I approach the witness?
Yes, you may.
Let the record reflect I'm showing opposing counsel what's been previously marked as Exhibit 1. Ms. Patterson, I'm handing you what's been previously marked as Exhibit 1. Now, you recognize that, don't you?
I do.
That's the advertisement that you used for the Top Gun 10 bike.
Yes, Texera did use this advertisement.
This is a fair and accurate representation of that advertisement.
It is the advertisement that Texera used.
Your Honor, at this time, plaintiff's counsel moves to admit Exhibit 1 into evidence.
Any objection?
Yes, Your Honor. Outside the presence, there is no evidence in this record that the plaintiff saw this advertisement, so it would be irrelevant and extremely prejudicial.
Your Honor, first and foremost, this is not irrelevant. Relevancy is evidence that has any tendency to make a fact of consequence more or less likely. Here at issue in this case is whether the marketing was defective, and this would make that more or less likely. Secondly, Your Honor, it's not prejudicial or probative because Ms. Day may or may not have seen it, because we anticipate they will try to offer warnings to you that they can't prove if she's seen or has not seen them, Your Honor. So if they want this to happen right now, everything would be excluded. What's good for the goose is good for the gander.
Well, we only have the goose yet. We don't have the gander. I'm going to admit it conditionally. You may move later on to exclude it if the evidence warrants it after Ms. Day is examined by you.
Yes, Your Honor.
Plaintiff's Exhibit 1 is admitted.
Your Honor, may I publish to the jury?
Yes, you may.
Now, looking at that advertisement, this is what you wanted to market to consumers.
We were marketing the Top Gun 10.
Now, on this advertisement, the bike rider is going down a rocky terrain.
The bike rider is going down a mountain.
Right, it's a mountain bike.
It is, exactly.
And now you heard your attorney say during opening statements that the root canal was a problem, right?
The root canal is where the accident occurred.
Your Honor, retrieving was previously been admitted as the picture of the root canal. Now I just want to compare this advertisement to that root canal. Now on the left, the Top Gun advertisement, that's a mountain, as you just said.
It is meant to evoke that image.
And the root canal, that's a dirt trail.
It is an unpaved trail, that's true.
So the image on the left that you marketed to your customers, you're saying they shouldn't do what you marketed.
No, the advertising image was merely to convey to the consumer that this was a mountain bike. We felt that the ad conveyed that.
Now you said it was a mountain bike. A mountain bike would include riding on a mountain.
Mountain bikes typically can be used to ride on unpaved surfaces. However, the Top Gun 10 was never marketed or never intended to be used by professionals or in very, very dangerous, hazardous type of riding, such as dirt jumping and things of that nature. And Texera was very clear that the bike should not be used in that manner.
You said that bike shouldn't be used on the dirt.
According to our warning, in professional level activities such as dirt jumping and the like.
And this is the advertisement that you put out with him on the rocks?
This is the advertising that Texera used, yes.
That's the image that you wanted people to see, right?
It is the ad that Texera used.
But that's not the image that you wanted to be responsible for.
I'm sorry, I don't understand your question.
I'll rephrase. That's the image that you put out, but you changed the warnings on the bike, that's right?
We changed the warnings on the bike?
Ms. Patterson, you put warnings on the bike
We did.
that you shouldn't be on a dirt road.
We put warnings on the bike that the bike was not meant to be used for professional mountain bike riding, such as dirt jumping and other more professional type of activities. This mountain bike was conceived and marketed and sold for a lower price point is to be accessible to the everyday consumer. It was never intended to be used by professional athletes.
Ms. Patterson, you said this bike should be used for leisure cross country. That's correct?
This bike could be used for...
No, I'm sorry. On your warning label, you put only use this bike for leisure cross country, correct?
We warned that it should not be used in professional level
Ms. Patterson, I want to
activities.
point you back to my question. On the warning label, you put only use for leisure cross country, correct?
Could I see the warning label?
Sure, if you don't remember the warnings you're giving out, no problem. Your Honor, showing opposing counsel was previously marked as Exhibit 2. May I approach the witness?
Yes, you may.
Now, you recognize that, right?
Yes, I do.
That's the warning label that we were talking about.
This is one of the warnings that we have for the bicycle, which is on the bike itself.
And that's the warning label that was on the Top Gun 10.
It is.
Now, Your Honor, plaintiff's counsel now moves to admit Exhibit 2 in evidence.
Any objection?
No objection, Your Honor.
Admitted.
Permission to publish to the jury, Your Honor?
Yes, granted.
Now, just so we're clear, because you couldn't remember, the very top of that warning label says use only for leisure cross country, yes or no?
Yes, because we have many warnings, and I want to be very clear and answer you truthfully as to what this particular warning said.
That looked like leisure cross country on the left to you?
If you're asking me if it says leisure cross country, it does.
Oh, and I'm sorry, on the left. That looked like leisure cross country bike riding to you?
It could be.
On a mountain?
It is a mountain bike.
Pass the witness, Your Honor.
All right, thank you.
Your Honor, permission to reapproach and retrieve?
Yes, you may.
Thank you.
Counsel, you may examine.
Ms. Patterson, I know you're just asking a bunch of questions, so I want the jury to get an ability to understand who you are. How long have you been the COO at Texera?
I have been at Texera for 5 years now.
And where do you currently live?
I live in San Francisco, California, where our headquarters are.
And now as the COO, what sort of roles do you entail? What does that entail?
Well, a COO is one of the top executives at a company like Texera, and as you can imagine, the COO stands for Chief Operating Officer, which means that I am in charge of all operations having to do with Texera.
Dealing with the design and the research and development, do you have an engineering degree?
I do. As a matter of fact, I have a master's in engineering from UC Berkeley, one of the top engineering schools in the country.
Ms. Patterson, let's switch now. Let's talk about the actual Top Gun 10 bike and how you went about manufacturing. How many bike models does Texera make?
We only make, very intentionally, 3 models. because we want to pour our expertise, our heart, and our soul into making those 3 bike models the best that they can be and something that the consumer can have confidence in.
Does the Top Gun 10, is that one of the 3 models that you manufacture?
We do.
How did you decide to go about selling or pricing your Top Gun 10 model?
Well, we wanted to make this idea of mountain biking, or in this particular case, biking on unpaved roads, more accessible to consumers. In other words, if, prior to the introduction of the Top Gun 10 and other mountain bikes like it, if you wanted to buy a mountain bike, you were probably looking at a price tag of $1,000 or more, which prevented many bike riders from purchasing this kind of bike, even though they may have wanted to. So the Top Gun 10 was aimed at that demographic who didn't want to do professional mountain biking activities like dirt jumping and things of that nature, but still wanted to ride on unpaved roads. So the Top Gun 10 is a model that we developed and sold for $500 in order to allow this type of consumer, this interested consumer, to have access to a mountain bike.
When you were deciding what price tag to put on the Top Gun 10 model, did you do any market studies that backed up the theory to put it at $500?
Yes, we did. We did a market study that showed us that for this type of mountain bike, one that is not for a professional use, that the consumer was more likely to buy or be willing to buy such a bike if it were $500 or less.
Well, let's talk more about the particular features and designs on the Top Gun 10. Is there what's called a quick release feature on your Top Gun models?
Yes, on the Top Gun 10 and 12.
Could you explain to us what a quick release feature is?
Well, as you can imagine, when you bike on unpaved surfaces, the possibility that something might happen to the bike tower, a bike tire, or something else, raises, exponentially than if you were on a nice paved road. So many consumers and mountain bike riders wanted ease and flexibility in order to, make those repairs, change the tire if necessary, quickly and efficiently. So the quick release mechanism was developed and placed on our bike in order to allow them to do that. And it is the kind of feature that the average mountain bike consumer really wants.
Well, let's talk more about how that quick release system works with your open fork designs. Let's look at a picture of one of your Top Gun bikes so you can kind of show us where on the bike all of these parts are.
Okay.
Okay, is Exhibit 22, is that one of your Top Gun model bikes, the Top Gun 10?
Yes, it is.
Now looking at that exhibit, where on the bike would be your open fork and disc brake?
It would be on the front wheel towards the center of the wheel.
Now let's look at the open fork system. Where does the axle fit into this open fork design?
I'm sorry, could you?
Yes, could you, I'll hold it for you, it's a little heavy. Could you just point to the jury where the axle on the wheel goes into this open fork design?
It goes right in the middle here.
Well, Ms. Patterson, obviously there's an opening right here. How do you make sure
Your
that
Honor, can I have permission to move around and see?
Yes, you may.
Obviously there's an opening right here. How do you make sure that once the axle is in the open-ended fork that it doesn't just slide out?
Well, because there's more than just simply an axle. There are bolts on either side of the axle on the fork. And really, what the quick release mechanism is intended to do is to make it easier to unscrew those bolts in order to remove the wheel. Now, understand that in order for the fork to do its job, that the axle must be very, very snugly placed and screwed in order for the bike to be assembled properly. So the quick release merely just assists the bike rider with the bolts that hold the axle securely in place.
Now, Ms. Patterson, let's switch to your disc brakes. And just very generally, could you explain to the jury if the disc brake is harder than the rim brake that you changed it out for?
No, the disc brake is a superior brake in that it provides consistent braking despite weather conditions and things of that nature. So prior to the installation of disc brakes, this particular model had what is called a rim brake. And the rim brake, in order to be effective, had to wrap around the rim, as you can expect, as well as the wheel. So what was happening is that if it was raining or anything like that, more force had to be used on the brake calipers in order to brake. And so you might lose braking efficiency with a rim brake.
Ms. Patterson, let me stop you there. Let's talk about when you actually first implemented those disc brakes.
Yes.
You were asked questions earlier about the previous company, Nexus.
Yes.
I want to be very clear about what you changed from the Nexus Top Gun 10 to the Texera Top Gun 10 when you got to the company.
The only thing that was changed was the brake. So moving from a rim brake to a disc brake.
And was that Nexus Top Gun 10 already manufactured, designed, and on the market before you put the disc brake on it?
Yes.
And is it industry standard for a manufacturer to run product tests on a product before they put it out onto the market?
Objection, Your Honor. This is an improper industry standard.
What do you mean by that?
Your Honor, to lay the foundation for an industry standard, he would have to provide, excuse me, Your Honor, testimony, evidence of what the standard of the industry is.
Well, I think she's testifying about what she believes the industry standard to be.
Yes, Your Honor.
All right.
You can, if you need me to repeat the question, I can.
Yes, please.
All right, so it's industry standard for when a manufacturer, before they put that product on the market, would they run their product tests?
Yes, before a product is introduced into the market, safety tests are run.
And before you introduced that disc brake to the Texera Top Gun 10, was that particular bike, frame and all, was it already on the market?
Yes, it was.
Now let's talk more about the fork design and how it all fits on there. You mentioned earlier that there's a quick release system.
Yes.
Why was the Top Gun sellers? Why was the Top Gun 10 your top seller with that quick release system?
Well, because it appealed to the consumer. It appealed to the use. Having those disc brakes provide the ability to brake more quickly in an efficient manner. And we believe that that is what appealed to Top Gun 10 purchasers.
And earlier you were showed some, the picture of the advertisement that you put out in your warnings. Yes. I want to put Exhibit 2, your warning label, back up on the screen. I want to ask you a question about it.
Okay.
Where on your Top Gun 10 bike is that warning located?
It is on the fork of the bike, so the part of the bike that is at issue here.
And earlier you were saying that you warned the customers that it's not a professional mountain bike. Where on the warning do you tell them that?
Well, the activities that we tell the consumer not to use the bike for are those types of professional, higher, harder bike riding activities, such as free riding, downhill, dirt jumping, or any hard riding. That is that refers to those professional level type activities.
On that warning, do you warn your customers about improperly using the bike?
We do. We say that if you engage in those activities, that the fork could fail, and obviously that might lead to a personal injury.
Is that warning that's on the fork itself, is that the only time that you warn your customers about your Top Gun 10 bike?
No, we also have warnings in our owner's manual, as that label indicates.
How are the warnings in the owner's manual different from the warning that's actually on the bike?
The owner's manual because there's more room in an owner's manual, is just a little, it explains a little bit more in terms of how to properly install the axle, how to properly make sure that you have put the bike together so that you can have, so that the bike can function properly. So in the owner's manual, we very specifically state how the axle needs to fit into the open fork, how tight the bolts on either side of the axle need to be. We're very, very clear, and we have multiple warnings about what will happen if it is not secured properly and tightly and snugly and all those sorts of things.
Well, Ms. Patterson, if you're creating this mountain bike, the Top Gun 10, why do you have to include the warning on the fork of this Top Gun 10 not to use it for any hard riding?
Because we just want to make it very clear to any bike rider that this bike was not manufactured and should not be used for those types of activities. Because, just in case there's any confusion on the consumer's part that they could use the bike in the way that professionals use it, we want it to be clear and let them know that this bike should not be used for those types of activities.
Thank you, Ms. Patterson. I have no further questions, Your Honor.
All right, thank you. Any redirect?
Yes, Your Honor.
And Ms. Patterson, you just said the instructions you provide have multiple
Warnings about what will happen if an axle's not in there properly.
We have multiple warnings about every stage of the installation process. We have a warning about what will happen if it is not completed correctly.
Your Honor, may I approach the witness?
Yes, you may.
Showing opposing counsel was previously admitted Exhibit 39. Ms. Patterson, I want you to find in there where you warn anybody of what will happen if the axle's not installed properly.
Are you asking me where, if the word axle is used?
No, I'm asking you about what you just said. Nowhere in there does it say if you don't install the axle properly, X will happen. It's not there, is it?
Well, what is here is...
I'm sorry, I'm asking you about what's not here. It's not there, is it?
Well, that's why I asked you if you wanted, if you're asking me if the word axle is used. Because if what you're asking me is the word axle used? No. However, how to install the quick release, in order to make sure that the bike is functioning properly, that language is in here, except that it is talked about clamping the wheels securely, and the word axle is not here.
I want to point you back to my question. Nowhere in that manual does it warn of what will happen if an axle is not clamped properly, correct? Not a how-to, Ms. Patterson. Nowhere does it say the effect of not clamping the axle properly.
It does not say it will lead to personal injury.
Thank you.
If that's what you mean.
Thank you. May I approach to retrieve? And now, Your Honor, may we be heard outside the presence of the jury?
Yes, you may.
Your Honor, on that direct cross-examination, because it's an adverse witness, they opened the door against a prior ruling that you made before you ruled that Albright could not be discussed because of 407. Your Honor, the advisory comments and the rules clearly state that if a witness gets on the stand and makes factual assertions that are contradicted by subsequent remedial measures, assertions like the product was the best or the safest, then it should be admissible under an impeachment standard, Your Honor.
All right. Good effort, counsel, but I'm sticking with my prior ruling.
Yes, Your Honor. Ms. Patterson, I want to put up Exhibit 1 again. Now, when you were just talking to your attorney, you said that a bike shouldn't be used for downhill rides?
That's what the label says, yes.
Hard riding?
Hard riding.
A mountain's hard, isn't it?
Guess it depends on the mountain.
Pass the witness, Your Honor.
All right, thank you. Anything further, counsel?
Just briefly, Your Honor.
All right, limited to the immediately preceding examination.
Absolutely. Ms. Patterson, if a customer was going to come into your store, would they have seen that advertisement before or after they bought the bike?
Before? I
And
would
after
expect-
and after they bought the bike, was there a warning stamped on the fork of the Top Gun 10?
There was.
What did that warning warn against?
It warned against using the bicycle in certain activities such as dirt jumping, hard riding, things of that nature.
Thank you, Ms. Patterson. No further questions, Your Honor.
No further
All
questions.
right, thank you. You may step down, Ms. Patterson.
Thank you.
You may call your next witness.
At this time, the plaintiff
what did y'all
calls
think
Professor
about
Don
that
Dellinger to the stand.
strategically?
Mr. Dellinger?
I think it was risky,
Please.
calling that particular witness, having all of that time go in and not having a real story of what actually happened on the trail, what happened to the plaintiff. So the jury's getting all of this information without an emotional connection to the plaintiff yet. And I think it's high risk, high reward. I mean, they won't know till the verdict comes in whether or not it works.
Yeah, we also were noting too, they used a lot of time with that witness. We'll have to see if it
Professor Don
affects.
Dellinger,
So now
once
coming to
seated,
the
please
stand
introduce
is the
yourself to our
expert
jury.
Joe Don Dellinger.
Joseph Don Dellinger. I'm a clinical associate professor at Baylor University.
I'm so sorry, Mr. Don Dellinger. What do you do for a living?
I currently teach in the engineering design course sequence at Baylor University. Our first semester engineering design course, we typically use design projects where we're designing road bikes for special use clients.
How did you become involved in this case, Professor Don Dellinger?
I was approached to determine whether or not there were defects in the design of the Top Gun 10 bicycle. It was an interesting case to me because it's synergistic with my other professional activities.
Before we get to your conclusion to whether the bike was defective, I'd like the jury to get a chance to know about your experience and expertise. Where'd you go to school?
I attended the University of Illinois, where I earned a bachelor's degree in mechanical engineering and a master's degree in industrial engineering.
Where have you worked professionally?
Since then, I worked as a product design engineer at Ford Motor Company for approximately 7 years in a variety of positions, including suspension design and vehicle systems engineering. Following that, I worked at General Motors Research and Development Center for approximately 16 years, involved primarily in data analytics activities, including safety analytics.
Have you published any articles?
I have published 3 book chapters. I have, including publications that have been accepted. I have 5 journal publications and approximately 24 peer-reviewed conference proceedings.
Your Honor, may I approach the witness?
Yes, you may.
Let the record reflect, I'm showing opposing counsel what's previously been marked as Exhibit 9. Oh, you can take it.
Oh, thank you.
Do you recognize what's previously been marked as Exhibit 9?
I do.
How do you recognize it?
This is my curriculum vitae.
Is that in the same or substantially similar condition as you last remember it?
It is.
Your Honor, at this time, the plaintiff moves to admit Exhibit 9 into evidence.
Any objection to 9?
No objection, Your Honor.
Admitted.
You can push that to the side. Now, what did you review in developing your opinion in today's case?
In today's case, I reviewed the depositions that were submitted. I also reviewed photographs of the race course, including University Parks Drive and the Top Gun Trail. There were diagrams with measurements of the race course. I reviewed those. I looked at the design of the Top Gun 10 bicycle, as well as reviewing designs of similar bicycles that were available in the market. I reviewed the product literature for those bicycles. Also reviewed relevant technical information, including physics equations for kinematics and strength of materials to investigate the possible failure modes.
After reviewing all of that, did you use it to develop your opinion?
I did.
And is that how another engineer would use methods to develop an opinion in this case?
I believe so.
Is that how you applied the methods in this case?
I did.
Your Honor, at this time, the plaintiff offers Professor Don Dellinger as an expert in engineering and accident reconstruction as it concerns bikes.
Any objection?
No objection, Your Honor.
So certified.
Now, Professor Don Dellinger, you told us a moment ago that you had reached a determination about whether the bike was defective. What is that?
I believe that this was a defective design.
Your Honor, permission for the witness to step down for a brief demonstrative?
Yes, you may.
Your Honor, may I relocate?
Yes, you may. Both counsel may relocate as needed to see any demonstration that may be taking place.
Now, you mentioned that you felt like the design was defective.
That's correct.
Specifically, why is that?
May I use the bicycle?
Absolutely. If the jurors can see us, Your Honor, are you fine with that?
Yes.
Okay. To demonstrate why I believe that there is a design defect in the combination of the open fork leg along with this type of disc brake in the location that it's used on this bicycle. In the original design, the rim brake was located in this location. And so if the wheel is spinning as it would in movement, the reaction force on the wheel is applied in a backward direction. Two things can happen with that reaction force. The intended consequence is that the reaction force will generate a torque that will slow down the wheel. It could also apply in translation, meaning it will move the wheel in the direction of the applied force. With a rim brake in this orientation, if the force is applied in this direction, it will push the wheel back into the fork dropout.
What will happen if there isn't a rim brake, something such as a disc brake?
So in the case of the disc brake, when the wheel is rotating in this direction and the brake is applied, the reaction force to stop the wheel is applied in a downward direction. And so if that downward force does not act to slow down the rotation of the wheel, it could move the wheel in a downward direction. And if it does move the wheel in a downward direction, with that open fork design, there's nothing to stop it. It will move down. Once it moves down, it is changing its loading condition from its designed loading condition of a bearing load to loading only the back portion of the fork dropout in a cantilever beam loading condition.
Let's pause right there so we can get the other demonstrators so they can see it. Now you mentioned the loading, just so they can get an up close and personal visual. What do you mean by that?
So, if the axle is seated in this fully upward position, it's experiencing a bearing loading condition. The load is distributed evenly across the entire surface area where it makes contact. That's a design loading condition. If the axle moves downward, such as it could when the disc brake is applied, if it is now in this condition, if a force is applied to the axle in a rearward direction, as it could be when the wheel makes impact with any obstacle on the road, it's applying load only to the back side of this open fork dropout, and this small area of the fork is acting as a beam that's bearing the entire load on this side and on this side. These two sides are bearing the entire load at a single point of whatever load can come back in through the wheel.
When they are bearing the entire load down here like this, what can happen?
That could cause a fracture of the material in this area.
And if there's a fracture at that area, what's going to happen to the bike?
At that point, the wheel would separate from the fork, causing loss of control of the bicycle.
Now you mentioned all of this happens with an open fork design. Is there another design that will prevent that from happening?
There is.
What design is that?
That would be the through axle closed end fork design.
Now with this closed fork design, why is this design better?
This design has the inherent advantage that the axle, you can see that when we remove the axle, it is surrounded 360 degrees. It's completely surrounded. So it is guaranteed to be loaded in its bearing loading condition, which is the strongest loading condition for this material. It does not matter in what direction a force is applied. It will remain in a bearing load, and it is impossible for the axle to move unless the material fails in a bearing loading condition.
So which design is safer for a bike?
I believe that design is inherently safer.
Was the closed fork design available to the defendant?
It was.
How do you know that to be true?
It was available on other bicycles at the time that the Top Gun 10 was brought to market.
So ultimately, what is your conclusion about the defective design of the Top Gun 10?
My conclusion is that the design was defective because an alternative, safer design was available and not implemented.
Thank you. Let's shift and talk about another defect that I think you studied, the marketing defect. What did you conclude about the marketing of the Top Gun 10?
I found that there were warnings that I expected to see and did not see in the documentation for the Top Gun 10 bicycle, specifically relating to the consequences of the axle located in positions other than its design intent position, being fully seated in the fork dropout.
Now you mentioned warnings. Are those the warnings that we looked at today?
These are the warnings that we looked at today did not include those statements.
Your Honor, retrieving what's already been discussed as Exhibit 2. Now, why is this warning inadequate?
This warning does not specifically cite the manner in which the fork could be misused. It says
go ahead.
Improper use of the fork. That does not specifically address the installation of the wheel.
Does this warning ever make mention that if the fork comes out, somebody could get hurt?
It does mention a risk of personal injury.
Does it mention a risk of serious injury or death?
No.
Did you see any such mention in another bike manufacturer's warnings?
I saw more specific language on the consequences and effects of misinstallation of the axle in the documentation of other bike manufacturers' designs.
You have permission to approach the witness?
Yes, you may.
Let the record reflect that showing opposing counsel was previously marked as Exhibit 40. Do you recognize what I'm handing you as Exhibit 40?
I do.
How do you recognize it?
This is a Cannondale owner's manual, which I consulted as I prepared my expert report for this trial.
And what does Cannondale manufacture specifically?
Cannondale manufactures mountain bikes, among other types of bicycles.
And is that manual in the same or substantially similar condition as you reviewed it when developing your opinion?
It is.
Your Honor, at this time, plaintiffs move to admit Exhibit 40 into evidence.
Objection?
No objection, Your Honor.
Admitted?
Permission to publish to the jury, Your Honor?
Yes, you may.
Now, you mentioned there was more specific language. Could you look to the warning that is orange and tell the jury what that specific language says?
This is the warning: riding with an improperly secured wheel can allow the wheel to wobble or fall off the bicycle or suddenly stop the wheel, which can cause serious injury or death. Therefore, it is essential that you ask your dealer to help you make sure you understand, or you make sure you know how to install and remove your wheels safely.
Thank you. Now, is that warning the one that you thought was appropriate?
Yes.
Why is this warning appropriate and the warning that they gave inappropriate?
Because it more specifically addresses both the installation of the axle in a proper orientation and clearly explains the consequences of misinstallation.
Thank you, and you can put that to the side. Finally, I'd like to talk with you about what you determined about Ms. Day's actions in this case. Did you develop an opinion about her actions?
I did.
What was that opinion?
My opinion is that any writing on her part was not material to the outcome of what happened that day on the race course, that it was not material to the failure of the bicycle fork.
How did you come to that conclusion?
Analyzing the speeds that Ms. Day could have attained regardless of her position on the race course and analyzing the strength of the bicycle dropout, I determined that provided that, or more appropriately, with the axle in a fully seated position, the axle was capable of sustaining a load that Ms. Day would have experienced entering the root canal trail, even at the highest possible speed that she could have attained at the trail entrance. I do not believe that excessive speed was a factor. The thing that I found that was a factor is that if the axle moves from its fully seated to its downward position, that the fork can lose up to 95% of its load-bearing capacity. And that is what I concluded was the causal factor in this accident, was a substantial loss of load-bearing capacity due to the migration of the axle.
Is that opinion supported by independent research?
It is.
Is that opinion supported by other Top Gun 10 design failures?
It appears to be.
Based on your analysis of this case, what is your opinion as to the reason why Ms. Day was injured?
I believe that the reason Ms. Day was injured was because the combination of the open-ended fork end design and the disc brake used on this bicycle allowed for migration of the axle to an unsafe position to the point that it could break even under ordinary loading in an off-road condition. And I believe this is what happened, and this is how the accident was caused.
Pass the witness, Your Honor.
Cross-examination.
Yeah, so that was, what a tall order that was for Tatiana to deal with that expert in the context of a shortened mock trial, but she did a very nice job. Got him up, got him talking. I really liked that. But man, it is tough to prove product liability case with one expert in limited time in this context, but she did a really nice job. I could feel she wanted to keep it moving. I think she did.
Yeah. Well, and it'll be interesting to see what Craig does on cross.
Yeah.
Before we get started, could you please help me out with the pronunciation of your last name again, please?
Dondelinger.
Dondelinger. If I butcher that, it is unintentional. I'm sorry. Professor Dondelinger, I want to start with the warning that you were shown. Now, the warning that's on the open-ended fork design of the Texera Top Gun 10 shows what the bike is supposed to be used for, right?
Shows use only for leisure cross country.
Right, it has the words use only for, correct?
Use only for leisure cross country.
And then right under that it says do not use for.
Do not use for.
And then under that it says improper use of this fork can result in fork failure, right?
Improper use of the fork can result in fork failure and personal injury.
Let's talk about the design of that open-ended fork system. Obviously, you know how to install the open-ended fork, right?
You're asking me if I know how to install
the wheel onto the bike.
Install the wheel onto the bike with an open-ended fork design.
You know how to install the wheel onto the Top Gun 10.
I believe so.
Because all you do is you take the wheel and you slide it into the open fork.
That is not all that needs to be done on this design.
Well, I was getting there.
Okay.
The first step is to take the axle that's on the wheel and it slides in this open-ended U-shape, right? That is step one.
Why don't you tell me what you believe the other steps are before I answer yes or no?
I'm going to be the one asking the questions here, Professor.
Sir.
So you take this design here, right? It slides down onto the wheel axle. You would at least agree with me on that.
I would agree that the fork slides down onto the axle.
And then all you have to do after that is tighten the lever.
You have not yet mentioned anything about the interface between the disc brake rotor and caliper.
All I'm trying to do here is let the jury understand that this wheel attaches to this fork. You would agree with me that the wheel goes on the fork.
I agree.
There's an axle on the wheel.
There's an axle on the wheel.
The axle goes in these two openings.
That is correct.
Once the axle is in these openings, you can tighten a lever.
There's a nut on the other side as well.
One of these sides has a lever.
One of the sides has a lever.
And that lever is used to tighten the axle into this opening.
Once the axle has been secured to an adequate amount of torque, the final step would be to act on the lever.
I'm glad you mentioned adequate amount of torque. Once you tighten this lever, you have to take the clamp and you actually have to move it up and tighten it, right?
Correct.
Now that's not really easy because it has to have an adequate amount of force. Right? That's what you just said?
Yes.
So a user putting on that front wheel would have to put a lot of force to get that clamp to tighten.
Define a lot of force.
That's the word you used. It would take a lot of force to put the clamp up and lock.
Adequate is not the same as a lot.
It would take adequate force.
Adequate amount of force to meet the industry standard.
Right. And the industry standard requires that that clamp be tightened.
Tightened.
And a user would feel if that clamp was not tight.
The user could feel if the clamp was not tight.
Okay. Now, let's talk about how that axle, we'll try to do this again, sits inside the opening design. You would agree with me at least that if the axle is secured, I think you said a bearing load. If the axle has a bearing load, it can withstand a lot of force.
If the axle is in a bearing load, yes, it can withstand more force.
So, and now what I mean by that is the axle is secured if it's all the way flush, correct?
If
this is unsecured. If there's room in between the axle and the end of this fork, it is unsecured. Professor, you are an expert in this area?
Yes, I am, and I got in trouble before for asking a question with a question. But if the question is whether or not the amount of force that you close the lever with depends on the position of the axle, that is not true.
No, we've moved on from the lever.
Okay.
Now we're talking about the axle.
Okay.
The axle goes into this open-ended design, and it's supposed to fit flush, right?
That is correct.
And all I'm asking is that if it fits flush, that's when it can withstand the most force.
That is correct.
So it would be important to know when that axle was unflush.
Yes.
You cannot tell this jury when this axle became unflush on May 30th.
That is not necessarily true. There are warning signs that the render could sense if the axle migrated from that position because of the disc brake on the bicycle.
There is nowhere in your report where you said at this moment the axle came loose, right?
That is correct.
So you do not know exactly when the axle came loose.
In the report, I posit that the axle migrated as a result of heavy braking and pointed out specific conditions under which it could have moved.
My question is rather simple. If the axle can move, you need to know when. And in your report, at no point did you say when exactly that axle moved from the flush position to the unflush position.
Jeff, you are asking.
Are you asking if I pointed out one specific point in the report conclusively when the axle moved?
Let me see if I can simplify this, Professor. Agree with me on this. There was at most 4 times where Ms. Day applied the disc brake on May 30th.
Correct.
You could not tell if the axle slid off on brake apply number 1.
I posit that it did not occur until the entrance of root canal. There was testimony in the report that the fork was capable of sustaining the load of entrance to root canal if the fork was in its fully seated position, but not if it was in a migrated position. So I believe, based on information that was stated in the report, that the axle did not migrate either until entry of the trail or some point thereafter.
I really appreciate that, but you understand that's not my question, so we're just going to move on. When you were forming your opinion, you actually took a site visit and went to look at the root canal trailhead, right?
I did.
And you actually determined that there was what you called a drop on the back end of the trailhead.
A drop.
That's the word you used, right?
Yes.
Because there was a 7-foot decline for the next 35 feet.
Okay, so we're talking about the downhill grade.
Right, so entering that trailhead, it's inclined.
Correct.
On the back side, it drops 7 feet for 35 feet, right?
So we're talking about the elevation change before and after entering the trail?
Yes, top of the incline to the bottom of the incline was 7 feet.
Top of the incline to the bottom was 7 feet, I agree with that.
In the ATA, the American Triathlon Law Association, and everything that you reviewed, you did not see where they had a warning at the front of that trailhead.
I did not see a warning from the trailhead.
The ATA,
when I visited the course.
well, in the materials that you reviewed about people talking about the course on May 30th, nobody mentioned a warning at the entrance to the trailhead.
I do not recall a warning at the entrance to the trailhead.
There was no flashing light saying that there's a ramp at the trailhead.
I do not recall any flashing lights at the entrance to the trailhead.
And obviously you do not recall the ATA putting a volunteer right there to warn the bicycle riders that they're about to make a sharp right turn on a ramp.
I do not recall any such thing.
Well, you do know that there were traffic cones leading down University.
I thought you said earlier that there were no cones on the course in the day of the race.
Well, that's right. There were no cones, except for the two at the beginning of the root canal entrance, right? You remember seeing those in the materials you reviewed?
Yes.
And then there were two at the entrance of the university, right?
Correct.
In between that, there were no traffic cones.
There were no cones.
And there was no volunteers anywhere on University to warn the riders that they're about to make a sharp right turn, right?
Could the cones at the entrance of the trail mark the turn onto root canal? That was my interpretation.
Again, if you don't mind, I'm going to ask the questions. There was not a volunteer in any of the materials you reviewed. You did not see if anybody said there was a volunteer on University Park Avenue.
I do not recall any mention of a volunteer in University Parks.
Thank you. No further questions.
Yes, Your Honor. We just talked about volunteers and cones and things like that. Would any of those things prevent a defective bike from breaking out from under a person?
I do not believe so. I believe that the bike was capable of sustaining the conditions on the road course, regardless of the speed or the entrance to root canal, if it performed as designed. The failure, in my opinion, occurred because the axle was allowed to migrate in the open fork design.
Absolutely. All right, thank you very much, sir. You may step down. All right, the jury looks like it needs a break, so we're going to take a break until 4.
It's always difficult to cross-examine a witness. I think that Craig handled it quite well, although obviously there was some battling back and forth, so to speak. I think one thing that Craig kind of missed is an answer that he got wasn't necessarily bad for him. Specifically, I think the expert said something along the lines of he's now on the witness stand indicating and positing that the accident actually happened at the entrance to the dirt trail, the entrance to the root canal. That's actually consistent with the defense theme, and hopefully he'll be able to recognize and realize that he can use that to his benefit, that that particular battle he won, although he wasn't getting the yes or no answer that he was looking for.
Yeah, we've definitely had some witnesses who were willing to fight back from the stand. There's been some difficulty with that, and it's always interesting to see with judges, if you don't know our ballot, there's a scoring for who handles witnesses better on direct and who handles them better on cross. It's interesting to take that witness factor in, right, Spence?
Absolutely. I mean, both witnesses have presented such interesting challenges for the advocates. It is so hard when you are up there and cross-examining somebody and not getting the demeanor you hoped or perhaps expected. It is so hard to stay on your game, and these folks are doing a great job of it, but it's hard. It is really hard stuff.
Well, and I will say, we've all been discussing the concern that we have because these rounds are timed, and how much time do they have left?
75 minutes per side, and that's opening, all witnesses, and cross. I mean, and closing, sorry. So, yeah, we're getting a little nervous here on their behalf.
Are we officially at mid-trial? Has the plaintiff rested, or are we just taking a break?
No, Judge Lynn called for a break.
Okay.
So we're taking one, and we'll have to see where this goes.
Well, since we have the time, I would love to talk about how the plaintiff's case actually called an adverse witness as their first witness. What do we think of that strategically? Is that going to benefit them, or how do we think that's going to play off?
As a plaintiff side attorney, I mean, that's sort of that would be my sort of default position, but there's a risk, and I think somebody pointed it out up here, which is you get to do your adverse direct, but then you've opened the door to them getting to, do whatever they want during the middle of your case in chief. I mean, that's a risk.
Well, and I thought Tatiana did a really nice job with the cross, but then I thought Craig clawed it back some. So, on balance, I'm not sure which way that went. I thought there were some very effective moments.
Right.
For both sides.
Well, I will say, if you're a plaintiff's lawyer and you want the jury to sympathize with your client, I don't know if they understand what happened yet as far as the story and the sympathy that you get by having Miss Day wheel herself up to the witness stand for the direct examination. I'm just unsure if this is coming across to the jury as clearly as maybe they believe it is.
Well, and that's a good point, because you do want, I think, on the plaintiff side, it to be about the defendant's bad conduct first. You want them to have knowing rule violations if you're a rules of the road follower or reptile.
Right. I mean, you want to characterize what it is that the defendant is doing as a company as an example of the type of conduct we do not want any large companies to be engaging in, because it could impact anybody who might come across their products. So that's why that's a major sort of default position for me. But then it's tough too. I think Liz, you had said earlier that if you don't know sort of the circumstances of the actual incident, well, it's kind of tough to start talking about the manufacturer of the product and all that stuff. So that's a tough balance.
And not only that, I mean, I agree, Tatiana, they're both doing a phenomenal job, but it coming out of the gate somewhat aggressive without necessarily warming up first to the jury and making sure that the jury has the warm and fuzzies about the plaintiff. It's just unclear from this perspective how that's coming across. Maybe in the jury box they get a different picture and a different feeling, but I do think that there were times where she was more aggressive than maybe we are at the case would necessarily handle yet.
I wonder if she could have spent a little more time in opening, because I felt like she had
we were
room
talking
in
a lot.
opening. Yeah, we were. Sorry, those of you watching at home, we're listening.
You were right.
It's our first time. But it did feel like maybe she could have warmed us up to Sarah Day a little bit more. You could have even done a nice contrast between what the defendant did wrong and Sarah's view that day. I think there was some room for that. Where do you think they're going to be able to go, or where do they have to go?
You mean how much time do they have left to go anyway?
Yes, honestly, this is making us so nervous. We keep looking at our watches.
Well, I'm thinking they're probably going to put on the plaintiff next, and then maybe plaintiff's case will rest. That's my prediction.
You'd think.
I don't know if you have a different game time prediction here. Same predictions?
I think you got to finish the plaintiff's case pronto.
Get out.
That's what you got to do.
You gotta get out.
Yeah, get in and out. The other thing that I thought was really well done by Craig was using the plaintiff's expert to establish his case against the course design and against the plaintiff herself to some extent. I like doing that through an adverse witness.
Yeah, I agree. And actually, so when I heard Craig talking about there is a defect in the design in the opening statement, I mean, of course, he was not talking about his own product, but to put the jury in the frame of you're looking for defects in designs worried me a little bit there, because he specifically doesn't want to have a certain defect found. But I think that it worked there. I think that he kind of made that a little bit more clear what he was up to. That he can actually talk about a defect in design that is part of this course and use their expert to do it.
I think that using the expert almost to accredit your own case as opposed to attacking an expert opinion. I don't know if I've ever crossed an expert in a real trial where they would change their opinion. They're not going to. It just doesn't happen. So to the extent that you can actually use an expert to corroborate your case and put your case theory and theme out there, I think is a brilliant move.
Well, and I would have liked to have seen both of our advocates harken back to those themes.
Yeah, right.
Maybe with the corporate rep talking about you didn't even test, so essentially Ms. Day became your crash test dummy.
Yeah.
Boy, there could have been some play there so that it
or
really
even
flows.
by Craig, I mean, he could have crossed about you didn't do an analysis of the design of the American Triathlon Association course. You didn't determine whether that design was defective.
Yeah.
Different ways that you can bring that theme and theory back. And I think that you've given a presentation that I've seen before talking about the various tunes or the what do you
theme
call
and
it?
variation.
Theme and variation. I always think of you when I think of different ways to throw those themes in during examinations of witnesses.
Yeah, I think this is a really good first round that we're seeing here. So what we are anticipating, there were 7 potential witnesses that could be called.
They're not going to have time for that.
They're not. What was interesting, though, one of the plaintiff's pretrial motions dealt with a witness, and Craig said, we're not calling him, and Judge Lynn made the point. I think she's been really good in this final round.
She's let them try their case.
No, and very patient with them.
Yeah.
But since you brought up motions, can we go back to that? Because we didn't really get a chance to comment on that. I found it an interesting use of your time during motions to bring up a motion that, first of all, could have easily been discussed with opposing counsel pre-trial. You wouldn't need to make it, whereas there were some serious evidentiary issues that arose during the testimony of Patterson that I think maybe would have and should have been a pretrial motion.
Yes, you couldn't hear us, but our entire panel was climbing out of their skins that some of this was not handled by motion in limine, which certainly in a real trial it would have been. So we don't know if this was a mock trial strategy.
Right.
Because, it's the classic, you couldn't unring that bell, and then you're differentiating nuances.
It's so true. I mean, and these students are super talented. They are coached by amazing coaches. I mean, they're making intentional decisions in there, right? I mean, they know what they're doing. So, it would be interesting to talk to them afterwards about what the strategy was behind that, because it's tough. If you want to keep something out, if you make your decision on your evidence, I want it out. Well, then you usually want to make the most efficient way of doing that, which is going to be your motion in limine, instead of sort of trying your luck out in the open waves of the ocean that is the case in chief.
And if I may, what I saw in the preliminary 4 rounds, a lot of the judges don't necessarily want very extensive or complicated pretrial motions, so maybe it was a strategic decision.
Sure.
But in a final round, you take a different position and a different perspective because you have a federal judge that's sitting on the bench. You have quite a few very good attorneys as well as previous Top Gun winners. So maybe given the audience, this is the best forum to actually change what your strategy is coming into the final round.
And I think that was the feedback from Judge Lynn. She said something like, we've been listening to 2016 or 2017 for a while now, which is a sweet way of saying, I'm not sure your objection's timely, counsel.
Right. In keeping with how she's handled the whole thing, she's, I thought that was
very gracious and deft.
Yeah.
So something we haven't talked about, Baylor's sort of notorious for throwing curveballs in
we're aware of
different places.
And
one of the curveballs that was thrown to these competitors just before the final round was a potentially sort of damning email from the company suggesting maybe Joe Dondelinger was correct about his concerns. Boy, there were all these evidentiary issues, and then just to make it a little harder, Professor Powell told them, and coaches, you don't get to coach anymore, yanked them out, and so these students. Now, we had a little problem with the feed. I haven't heard the plaintiff trying to use this.
No, and that would have been the opportunity, wouldn't it, during Patterson? But I don't know if that was a bad decision. I think that may have had its own whole entire realm of evidentiary issues that could have come up.
And we're talking about time problems, I mean. So.
Well, and I will say that although the coaches were not allowed to talk to their students, I don't think Judge Roberts or Dan Tilley has ever watched a round in their entire coaching career. So they're just enjoying having to be away from this.
Yeah, this is something that's very interesting about Top Gun. The coaches fall into 2 different categories. You obviously can't scout other teams, but some of the coaches will watch and really actively provide feedback. Others can't stand to be in the room. Which side do you 2 fall on?
Well, he's just here for fun, but I'm a hybrid coach, right? So I find that it's impossible to have all of the material ready for both 1 and 2, at least for me, for both rounds. So normally during the first round, I'd like to sit in and see some of it, and then make sure that I use the second half of the case to go and get the binder and all of the materials ready for the afternoon rounds. If I had it my way, I would actually prefer to watch. To be able to give the feedback, but I find that in the unique circumstances of this competition, I'm unfortunately almost administrative help or a secretary for my students during the rounds.
Yeah. Now there's something very interesting happening. Look, the second chair for the plaintiff, so our judges aren't in yet, but the second chair for the plaintiff is repositioning. Yeah, I thought
Why
that was
not wait?
very interesting.
That's a moment. Not only wait, but we got a comment, and I tend to agree with it. Let her wheel herself up so that the jury can actually see how difficult it is for this woman who is now confined to a wheelchair due to the fact that the defendant designed a defective product.
Yeah, maybe they are testing it out. And boy, that I really applaud.
Yes.
This is in our largest room here in the law school, our room 127, that sometimes gets called the Thunderdome.
The Thunderdome,
It's so big.
yes.
And I would not want to have that happen for the first time ever with a jury in the box. So I really
it's good thinking.
applaud plaintiffs testing this out to see how it's
It
going
is
to
good
work.
thinking.
Yeah, and also look at Tatiana adjusting the podium
set up.
so that it's in there. You know, every year there are aspects where we think, let's see how they handle the real world, and having a catastrophically injured client is one of them. So folks, we can see the judge and the panel coming back in, so it'll be really interesting. We're guessing Sarah Day is going to be your next witness.
Be seated, please. Ms. Terry, you may call the next witness.
At this time, we're planning to call Sarah Day to the stand.
Right. This day, if it is inconvenient for you to get into the jury box, you may just sit near the jury box. Would you raise your right hand and repeat me? You solemnly swear or affirm that all the testimony you're about to give in the matter now before the court will be the truth, whole truth, and nothing but the truth.
Ms. Day, once you're ready, if you could please introduce yourself to our jury.
I'm Sarah Day.
Are you married?
I am. My husband's right there, Ted.
Do you have any children?
I do.
How many?
2 girls, Nicole and Ashley. They're both in college.
What do you do for a living, Miss Day?
I was vice president at Dell. I was head of HR. I'm looking for work right now.
Why is it that you no longer work at Dell?
After I lost the use of my legs and was confined to this wheelchair, it made it very difficult. Dell was so good to me. They offered me a different position, but it just wasn't the same. I was accustomed to running HR, to being a vice president, and all that went with that. And it just, for them to move me to a lesser role, I didn't want anybody to pity me. And so it just could not work. So I resigned. I felt like I just could not continue at Dell in my old life because I didn't have my old life anymore.
I want to turn and talk about why you no longer have the life that you used to have. When were you involved in the bike accident with the Top Gun 10?
It was in Waco at the Texera Memorial, Doris Miller Memorial in June of 2016.
Now, when you went to the Doris Miller Memorial, did you take a Top Gun 10 bike?
I did.
How long have you had a Top Gun 10 bike?
I'd had that bike about a year, and that was about my 5th triathlon on it.
Did you know how to use it?
Absolutely. I'd been doing triathlons at that point about 6 years and had done lots of them. I had done more road triathlons than off-road, but I'd done about 45 total, about 30 on the road and about 15 on the trails.
Are you accustomed to using the open fork design to put your wheel on the bike?
Absolutely. In fact, my road bike had the same design.
Would you ever not properly secure that axle?
Absolutely not. I understand how important that is. I needed that quick release. I thought that really attracted me to that bike because my road bike is that way. I drive a Jeep, and so I need to be able to take that front tire off very easily. And so I've been doing it that way for years. So I've understood how important it is that you properly secure it every time you put that wheel back on.
I want to shift and talk about how you prepared for the race. Did you do any preparation before the race?
We got to Waco the night before, and my dear friend Grace and we went, and we always check out the race course. We had studied the map before we come. We always do that. It's always available online. So we knew what the course was going to be like. But you never really know what the transitions are going to be until you get there. And it's each of these races, they're all set up differently. You never know what you're going to be really look at in terms of setup and transition. So absolutely, the night before, Grace and I had gone, so we knew where we would start the race in the swim, where we would come out of the water, where the run. This one was a different order, so that was interesting. But we wanted to know exactly what we were going to be doing at each stage. So yes, we went to each of the transition points. We walked through it. We didn't do the whole course, but we wanted to make sure we were comfortable with kind of the circumstances.
As an athlete, do you care about your own safety?
You know, absolutely. I mean, it would be silly not to. Just absolutely. I mean, all of us. When you get into this, it's like a family. You train with the group, and you teach each other. And so I learned so much from my tri buddies. I learned the things to do and to not do. So when I first started, I didn't know any of this, but I've been 6 years in, and I had done a lot of rides, a lot of transitions, and so yeah, absolutely. I knew safety was really important.
I want to turn and talk about the route of the race. Mm-hmm. You mentioned it was in a different order. What 1, 2, 3 order was this race in?
Typically, you swim, and then you hop on a bike, and then you run. This one they did differently. We swam, and then we ran, and then we were to get on the bike.
Your Honor, permission to retrieve an exhibit?
Yes.
Now I want to map out what you were talking about with the bike portion, and I'll be your, proxy just to show the jury what's happening.
Thank you.
So you mentioned there's a transition area. Where is the transition area for the bikes?
There's the clubhouse, and it was on this just below and to the right of the clubhouse. So that was the Jacob's Ladder where the light is. Jacob's Ladder is where we came off of the run, up Jacob's Ladder to the top of that grassy area.
And where is the transition area?
The transition area, I can point to it. I don't know if y'all can see. It was sort of right in that area.
I think my co-counsel is going to follow with the laser. Do you
Okay.
mean, I'll point, do you mean that it's right here?
Yes, it was right in here, coming this way out to come, yes.
So now you're at the transition area, you're on your bike, what do you do next?
You get on your bike, well, you change your shoes, you do all those things that you're doing in that transition. You grab your bike. They won't let you get on your bike until you're out of the transition, and as soon as you're out you jump on the bike, you clip your shoes in, and you take off riding. And I went down that sidewalk.
So you take off riding, and then what has to happen?
You have to make a hard right to get on to the road. And
after that hard right, what did you do?
I went, straight. The night before we'd walk, so I knew exactly where I was going to be going, and I knew where the root canal was. They had it clearly marked. You knew where you were coming to. There were cones, there were some flags, which is typical for tries. I mean, they marked the trail, and we knew where we were going.
So you said you were up and you were coming to the root canal. Once you got to the root canal, what did you have to do?
I have to slow down and take a really hard right. There was a lip, and then there was just, some straightaway, but then there was another hard right very quickly after the sign in the tree. So it was going to be hard break, make a hard right, and then I was supposed to go straight for just a little bit and make another hard right.
Well, you mentioned supposed to. After you got onto the root canal, what happened?
It's kind of fuzzy. I was headed down there, and I actually am a fairly cautious rider. So when I'm riding and I'm uncomfortable, my hands are on the brakes. I am ready to do the hard break. And the night before, I had seen the transition from the road to the trail has this lip. And so if I'd been one of those professional riders, I would have just flown off of that and on down the trail, but that is not me. I am not that experienced, and so I knew to be careful. Hard brake to come in off that lip and down the trail, again, expecting to then turn right. And I really am not exactly sure what happened. I mean, I did hear this weird noise, and so I thought, did my brakes break?
What was the noise? What did the noise sound like?
I mean, it was a metallic sort of something. I don't know if it was snapping, breaking, scraping, because sometimes when bike parts are rubbing together, it's metal on metal. I didn't know exactly what it was, but it was just sort of, and then I felt like I was free falling. I was suddenly going forward, not in the way that I would expected to when I'm on a bike and the wheel's under me. So something happened. And then, I blanked. I don't know what happened after that.
Pass the witness.
Cross-examination.
Wow, that was a really abrupt transition. I wonder if she's feeling that time pressure.
First, start with some questions
Absolutely.
about your triathlon experience. You started running triathlons in 2010, right? I just need a verbal answer for the record, if you don't mind.
I'm sorry?
I need a verbal answer for the record. Just so the court order is good.
Yes.
And since 2010, you said you have been in 45 triathlons.
Yes.
There's a difference between on-road and off-road triathlons.
Yes.
You competed in 30 on-road.
Yes.
And then 15 off-road.
Yes.
The difference between the on-road and the off-road is that the off-road triathlons add a different element.
Yes.
A rider can experience downed tree limbs on an off-road triathlon.
Yes.
They can experience rocks in the trail.
Yes.
In fact, as you said, that in an off-road triathlon, you could pull up on a trail and it could just be completely washed out.
Yes.
And you knew that in the off-road triathlon, you had to pay special attention because of those hazards.
Yes.
And now, Ms. Day, you would agree with me that at the end of a triathlon, you're pretty mentally exhausted.
Oh, it depends on the length. I did different lengths, and my level of fatigue at the end of the triathlon just depended on the length. There were some tries where my group and I, that was just our Sunday morning warm-up. We then went for a 50-mile bike ride after a triathlon.
You would at least agree with me that before the triathlon and after the triathlon, you're at least a little more fatigued.
You're immediately after, honestly, you're exhilarated. Maybe hours later, maybe the fatigue sits in, but it's an adrenaline rush to do these triathlons.
But you will agree that in these off-road triathlons, you have to pay careful attention.
Yes.
You went to the Doris Miller Triathlon the day before on May 29th.
Yes.
And so you knew it was an off-road triathlon.
Yes.
In fact, you walked the course the day before.
I walked parts of it. No, you don't walk the whole course.
Well, you've said before you walked each trail.
No, I didn't. Well, yeah, yes, in a sense, but you really aren't, you can't do it would take you hours to do that. So no, you go hit the parts of the course, you know what the course is, you know where your trouble spots are going to be.
When you went the day before on May 29th, you went to see the Root Canal Trail.
Absolutely.
And you walked the Root Canal Trail.
Yes, I did.
You walked the entire Root Canal Trail.
Yes, I did.
Now, before you got to the Root Canal Trail on May 29th, you started walking from the bike staging area that you showed us.
Yes.
And you walked down University.
Mm-hmm. Yes.
And down to the Root Canal.
Yes.
Now, you were walking with Miss Grace Jones that day.
Yes.
You and Grace started walking through the triathlon the day before at 6 p.m.
Yes.
And the ATA was closing down the preview for the competitors at 7 p.m.
Yes.
So just an hour before they closed off the course to the competitors, you did not see any cones marking the bike lane on University.
No.
You did not see any cones all the way down University that would prevent you from going to the left side of the road.
Yeah, I don't remember if they had the 2 cones. I don't remember exactly how many were the night before.
Well, you've never said that you remember seeing any the night before, right?
I don't remember.
And just an hour before they shut down the preview for the customers, there were no barricades that would prevent you from going to the left side of University.
Yeah, that's not that unusual.
Well, you don't remember seeing any installation of any warning signs that were being put up an hour before they shut down the
No.
competition preview?
No.
No, you didn't see any spray painted rocks on the root canal trail?
They would have to paint an awful lot of rocks if they were going to spray paint all the rocks. I mean, it's an off-road trail.
Well, on the root canal trail, there's only one part of that trail that has that set of rocks, right?
Well, that set of rocks, but there are roots, there are other rocks. I mean, it's a trail. Those trails are filled with rocks and roots.
Well, Miss Dave, on the root canal trail, that pile of rocks was not spray painted.
No, it wasn't. Neither were any of the other rocks that were on the trails that day.
No other rocks were spray painted.
I don't know. I didn't get to do the whole trail, but that was not something that I noticed that I was going to have to worry about.
And on the root canal trail, the day before, you did not see any flags outlining the boundaries for those rocks.
Did not.
You did not see any signs telling riders to stay left.
To stay left?
Stay left of the rocks on the
Oh,
root
no.
canal.
Did not.
And on May 30th, you did not see any of those things either.
I did not.
On May 30th, when you were coming down to University, there were no volunteers out there.
I don't remember seeing a volunteer.
Well, you do remember seeing a volunteer at the bike staging area.
Yes.
And now, just so we're clear, at the bike staging area, the only thing you do is put on your shoes, right?
Yes.
And then you climb on top of your bike.
Yes. I mean, you could do whatever you want in the transition, but
Well-
I did not. I just put on my shoes, hopped on my bike, and out of the transition.
And the ATA made sure to have volunteers at that part.
Yes.
And now, from that staging area onto University, that's only a 30-second bike ride, right?
Yeah, I didn't time it, but it's a short ride.
It's a very short ride, right?
Yes.
And there was no volunteers on University telling you to slow down.
I don't remember any.
And at the entrance to the root canal, there was nobody telling you to slow down.
Yeah, I don't remember anyone.
And there were no instructions the day before, verbally or written, that told you to beware of the root canal trail.
To beware, no, not that one in particular, no.
They did not tell you that you needed to watch your speed entering that root canal trail.
Did not.
Miss Day, before you started the race on May 30th, you installed your front wheel onto your Top Gun 10, right?
I did.
Just like you said you've done hundreds of times.
Yes.
And you know that warning that's on the fork of your bike, right?
I do now. Did I know it before? No.
Miss Day, you do remember seeing the warning on the screen, right?
Yes, I do.
And it was bright yellow.
It's bright yellow.
And it's right there on the matte black fork.
Yes.
And you're telling this jury that you've never seen that warning before?
To say I've not seen it would be not a truth. To say that I had read it and carefully studied it at the time, no. Looking at it now, it still wouldn't have kept me from riding that bike in that try or any of the others. That warning wouldn't have scared me away.
Miss Day, I appreciate that, but you at least read that warning at the very least one time, right?
Objection, Your Honor, asked and answered.
You may answer.
You've at least read the warning at least one time.
Now, do I have a recollection of studying that label before? No, I don't. I can't say that I have a recollection of reading carefully that label before.
So it would be fair to say that you didn't understand the proper use for that bike.
Oh, I sure thought I did.
Well, you didn't know that bike's limitations, did you?
I knew that that bike was being ridden by lots of competitors in off-road triathlons. That's why I bought that bike.
You would agree with me that in order to understand how to use something, you would want to look at the instructions, right?
The instructions, yes, but again, these are clubs. You get into triathlons, you're with your people, you have conversations. This was a bike that was recommended. Did I read every word of the owner's manual? No, I did not.
Ms. Day, again, that wasn't my question, but now this warning label was on the bike, and you're telling the jury that today's the first day you've read it.
Today's not the first day. What I said was, do I have a recollection of carefully reading the language of the warning label before? No, I don't.
Okay, well, let's talk about, again, when you installed that bike. You said that on May 30th, you do not specifically remember clamping down the lever all the way.
On any one day, I don't remember, but as a routine, I just did it every day. It was something I did every day at that point in my life.
Ms. Day, on May 30th, you do not specifically remember taking that clamp and forcing it into position.
I don't, but I had such experience in doing that. There were plenty of times when if you don't have it just right, it won't clamp right. So it's a matter of you have to spin it in that lever a certain number of times to make sure that you can get the right torque so it's tight enough. So that's just part of your routine, to know that you've done it so it's tight enough so it'll be secure, and that you have done it tight enough, and if you clamp it too early, it's not tight enough, and you got to pull it back off and spin it some more. So yeah, I mean, don't have a recollection, but I know what my routine was, and I know how important that clamp is.
You have previously testified before that you do not specifically remember securely clamping the screw on
no
the
Objection, Your Honor. Asked and answered.
All right, let's just move along, counsel.
But as you said, it was a habit. You did it every time.
Yes.
You were sure that you did it every time.
Yes.
Would you say you've done it hundreds of times?
Yes, between my road bike and my trail bike, absolutely.
And
I had. Obviously, I haven't done it in a while.
And the hundreds of times that you remember putting it on right, you've never had an accident, right?
No.
Just the day that you can't remember if you completely secured it.
There are plenty of days I can't remember if I did it. I also said that earlier. I can't remember on any given day the specific action of doing that, but I know what my habit was.
Ms. Day, we're talking about May 30th, the day
Yes,
of your accident.
Yes, sir.
On that day, you do not remember putting that clamp all the way up after screwing it in.
Your Honor, asked and answered.
This is the last time I'm going to let you ask that question. Go ahead. You may answer.
I do not have a specific recollection of making sure that clamp was secure on that day.
And that is the day you had your accident.
That is the day my life as I knew it ended, yes.
Thank you. No further questions, Your Honor.
Any redirect?
No redirect, Your
All
Honor.
right, thank you very much. You may return to counsel table.
Thank you.
Ms. Day?
Your Honor, the plaintiff rests our case in chief.
All right, thank you.
Okay, that was a really interesting end. What did y'all think about that?
I think he was still frustrated from the cross. If he was not still frustrated from that cross-examination, I don't think he would have gone at her like that. And going at her like that was just not helpful for him.
It became an argument more than a cross-examination at some point there. I think he went a couple questions too far.
And that judicial admonition at the end, this is the last time, ow. But gutsy by Tatiana to say, no question, she'd had a winning answer. All right,
Absolutely.
so the plaintiff has rested. Here's the defense case in chief.
All right, ladies and gentlemen, ATA is not now a party to this case, but you will be asked certain questions about ATA when I give you the court's instructions.
Your Honor, if we could be heard, we actually do believe this witness doesn't fall under the 611 adverse party because this witness is a named party in this case today.
All right. For these purposes, I'll take this up with counsel when we work on the charge.
Yes, sir.
You may proceed.
Could you please introduce yourself to the jury?
Yes, my name is Jensen Stewart.
And Mr. Stewart, you work at the American Triathlon Association.
That's correct.
You are an event coordinator.
Correct.
You are in charge of organizing the Doris Miller Triathlon.
Yes, I was.
In fact, you've been in charge of organizing that triathlon since at least 2012.
Yes.
Now, you actually planned to have volunteers on the course that day.
We had volunteers all over the course.
You did not have any volunteers down University Park.
That's correct. Where the bike trail ran, or the bicyclists came and went down University Parks, there were not volunteers there.
But you had planned to have volunteers there.
Yes, I had volunteers scheduled to come in, but they canceled about 30 minutes before the competition began that morning.
So you had a man and a wife that had agreed to be your volunteers to stand on University Park.
Correct.
And you told us that 30 minutes before the race, they decided that they didn't want to be volunteers anymore.
Well, they had a family emergency come up, so there was no way they could get there.
Right. And you weren't able to find any volunteers to replace them.
No, it was too late. I mean, the competition was about to begin. I didn't have time to find new volunteers. Everybody else was assigned to their locations already.
Now, Mr. Stewart, you were actually working the triathlon that day.
Yes, I had to work the check-in desk that morning.
So you weren't able to go on university and replace those volunteers?
No, I didn't.
You weren't able to, or you did not?
No, I could not. I had other responsibilities.
You had to work the check-in?
Correct.
You would agree with me that after the race starts, there's nobody else to check in?
That's correct.
So after the race started, you could have actually walked yourself to University Drive and stood there as a volunteer?
Well, I didn't see the need to do that because I put cones out there for the bicyclists to follow.
Well, Mr. Stewart, you're telling this jury that you did not see the need to put volunteers on University Drive?
Right, not after I'd put the cones there.
Well, before you put the cones there, you actually planned to have volunteers on University Drive before the couple bailed on you.
That was our plan, yes, but we've done it both ways. It's not absolutely essential to have volunteers there if you put cones out to direct the traffic, which is what I did.
Now, you just told us that you've been designing this triathlon since 2012.
Yes, I've been actually working with the ATA for 12 years, so I've been doing it a number of years. I don't know exactly how many years, but...
Well, let's talk about 2012 specifically with the Doris Miller. That route down University used to be the running portion.
I don't really remember that.
Well, let me show you Exhibit 32. May I approach the witness, Your Honor?
Yes, you may.
Mr. Stewart, I'm showing you what's been pre-marked for identification, Exhibit 32. You recognize this exhibit, right?
I've seen that exhibit before, yeah.
Right, you were shown this exhibit at your deposition.
Yes, correct.
This is a picture of the running portion of your triathlon design in 2012.
I don't know that. If you tell me that, I guess I can accept that. I mean, I recognize this as University Parks Drive.
So you would at least agree that this is University Parks Drive?
Yes.
And this was during a triathlon?
It appears that it is, yes. I didn't take the photograph, so I don't know.
Well, since you were shown the photograph, it hasn't been changed or altered in any way.
Okay.
Right?
It doesn't look like it, no.
Your Honor, the defense offers Exhibit 32 into evidence.
Any objection?
Yes, Your Honor. Lack of personal knowledge, as witnesses just said. He doesn't really know what this is or what opposing counsel is speaking of.
Well, counsel, to the extent you're offering that as depicting the condition at a particular date, I don't know how the witness can authenticate it on that basis.
Well, Your Honor, the witness was shown this in his deposition.
For what purposes are you offering that? To demonstrate what?
To show that this was a previous triathlon conducted with the running portion down University and the number of cones used in the running portion in 2012.
And in the witness's deposition, did he say that?
He was shown this deposition and recognized this as University Drive in 2012, and he knew that he put the cones there.
Okay, well, I didn't hear that testimony. You best develop that.
Mr. Stewart, you remember seeing this picture in your deposition?
I remember you showed me, or someone showed me that picture at my deposition, yes.
And you remember saying that you put these cones here?
Yes.
And you were operating a triathlon in 2012?
Correct.
And this is University Parks Drive?
It appears to be, yes.
And this is what University Parks Drive would have looked like on May 30, 2016?
Yes.
This picture's not been changed or altered since I last showed it to you?
Doesn't appear to be, no.
Your Honor, the defense offers Exhibit 32 into evidence.
We object on the same arguments, Your Honor. You just said the exact same thing.
All right, that's admitted. Objection overruled.
Move it publish it to the jury.
Yes, you may.
Mr. Stewart, that's the exhibit that we were just talking about.
Correct.
Now, before we go into the specifics of that picture, you told us that on May 30th, you put out cones on University Park Drive.
Yes.
How many cones did you put out? You said 5?
I put out 5, yes.
You put out 2 at the entrance to University.
Correct.
And you claim that you put 1 in the middle of the University Drive.
I did put 1 in the halfway down between the entrance onto University Park and the root canal. I put 1 there.
You put 1 at the root canal entrance.
No, I put 2 at the root canal entrance, 2 at the entrance to University Parks off of the sidewalk, and 1 halfway between at about the location of that oak tree, I think.
And that was during a biking portion of a triathlon, correct?
Yes.
And now this picture is from 2012, as we established.
Okay.
Right?
You say it is. I assume it is, yes.
And you said that that is University Parks Drive.
Yes, I think that's University Parks Drive.
And you were operating the Doris Miller Triathlon in 2012.
I was.
And now at the top of that picture, right there in the middle, what looks like the back, it looks like somebody's running right there, right?
It does appear there's a runner there. Yes, I see that.
Looks like there might be a couple of runners.
It looks that way, yes.
And there's an arrow on the right side of the road.
I see the arrow, yes.
Showing those runners where to go.
It looks like that's what it was doing, yes.
And now you said that you put 5 cones there for a biking portion.
Correct.
You would agree with me that biking part of the triathlon is more dangerous than the running part, right?
I'm not sure I can say that biking is more dangerous generally than running. I mean, I think there's probably dangerous parts to both parts of the triathlon.
Well, you
so
would
to say one is more dangerous, I'm not sure I can do that.
Well, you wouldn't be surprised to know that some of your competitors classify the biking part as more dangerous than the running part.
Objection, Your Honor, lack of personal knowledge.
Well, we'll see. Overruled.
I'm sorry, can you repeat the question?
Yes, you would not be surprised to know that your competitors think that the biking part of a triathlon is more dangerous than just the running part.
That wouldn't surprise me, no.
So now, you put, let's see, what is that, 12 or 13 cones in 2012?
Well, what I'm looking at, 1, 2, 3, 4.
Well, Stephanie, will you zoom out, please? Thank you.
1, 2, 3, 4, 5, 6, 10, 12, something like that, maybe. I don't know.
About 10 or 12, right?
I haven't counted them exactly, but however many there is how many I put there that day.
And there were, as you put, 5 on May 30th.
Correct, yes.
But there was no warning sign actually at the root canal entrance.
Correct, there was no sign there.
There was nothing saying that there's a ramp coming up.
No.
There was nothing there saying watch your speed.
No.
There was nothing there saying slow down.
No.
And we've already established there were no volunteers there to do that.
Correct.
And now, going into the root canal trail itself, you did not have the rocks in the middle of that road marked.
I mean, in the middle of the trail.
Middle of the trail, I'm sorry. In the middle of the root canal trail, you did not have the rocks marked.
No, I did not.
You knew the rocks were there, right?
There's rocks all over the bike paths out there.
Well, these rocks specifically are in the middle of your dirt trail, right?
I guess they are. There are rocks all over the place. In the middle, on the sides, it's a rocky terrain in some places.
Well, now you would agree with me that it would be important to know whether there was a hazard in the middle of your road during a triathlon.
Well, yes, and that's why we open it up to the competitors to look at before the race begins.
And you did not mark those rocks at all?
No.
You did not have them flagged?
Well, you can't mark every rock or flag every rock on the course. Partly that would defeat the purpose of the competition.
Let's look at a picture of what the root canal looked like on May 30th. This is the entrance to the root canal.
Yeah, it looks like that, yes. I see the root canal sign there.
Well, let's zoom in to where the rocks are. You see those rocks there in the middle of the trail?
I think I do.
Right there in the trail, those are rocks.
Yeah, I see that, okay.
There are no other rocks on the left side of those.
I don't see any.
You don't see any rocks in front or behind?
I don't think so.
Those rocks that are in the middle of that trail are not spray painted.
They're not.
They're not flagged.
They're not.
And they were not flagged or spray painted on May 30th.
They were not.
And now, there was no alternative route on May 30th that these riders could take.
No, the root canal was part of the competition. They had to take that route.
So if the bikers wanted to finish that triathlon, they were required to go down the root canal trail?
Yes.
With no warning?
Well, no specific warning about those rocks, I guess.
Mr. Stewart.
Nor any other rock on the path.
Mr. Stewart, there was no warning at all, rock or otherwise, about the root canal trail?
No written warning, no.
No verbal warning either?
No verbal warning.
Thank you. No further questions.
You may examine.
Mr. Stewart, you designed a safe course, right?
A safe course?
Yes.
Yes.
You designed a course that athletes could reasonably do.
Yes.
You designed a course that reasonable triathletes sign up for.
Correct. They come from all over the country to do this.
Right, it's a popular race.
Yes,
Right here in Waco.
yes,
People want to do this race,
they do.
and you make it safe for them to do.
Yes.
Okay, I want to shift and talk about the volunteers, cones, and everything else that was just discussed. Now, were asked, was there a volunteer outside on that trail? You were asked about a volunteer on that trail, correct?
Yeah, we did not have volunteers on the University Parks Road.
You had cones.
I'm sorry?
You had cones.
Yes, I put cones out there myself.
Just so everybody is clear, if a volunteer tells somebody to slow down, that's not going to stop a defective bike from braking, is it?
I wouldn't think so, no.
If a cone tells somebody to make a turn, that's not going to stop a defective bike from braking under a person.
I don't think so.
If a person's riding a little fast and the volunteer says, hey, a turn is coming, and their bike's about to brake, volunteer can't do anything about it.
Volunteer couldn't prevent that.
Right. In fact, if a bike is about to brake up under a rider, a volunteer likely wouldn't even see it.
Probably not.
So quite honestly, if a bike is defective, a volunteer really can't do anything.
I wouldn't think so. There's nothing the volunteer can do to stop the bike from braking if it's going to brake.
Pass the witness.
Anything further?
Yes, Your Honor, just briefly. You're asked a lot about what the volunteers could not do. A volunteer could tell the riders to watch out for the rock, right?
I'm not sure they would, in that circumstance, point out one rock on the trail. If you're talking about that one rock on the root canal.
A volunteer, if they were to point it out, they could tell the rider that there's a rock there.
I guess physically a volunteer could say that. Whether they would or whether it would even be advisable, I don't know.
And a warning could say, there's a rock in the middle of the path.
Theoretically, a warning could say that, yes.
And theoretically, you could have told every one of your competitors that the day before the race.
But I would have had to tell them about every rock on the entire trail, and I just don't think that's reasonable.
Mr. Stewart, we're not talking about every rock in the middle of this trail. We're talking about the rock where Ms. Day specifically had her accident. You did not have...
Objection, Your Honor. Assuming facts, not in evidence.
All right, overruled. You may proceed, Counsel.
You did not have that mark where Ms. Day had her accident. You did not have that rock marked.
I did not, no.
Thank you. No further questions.
No questions, Your Honor.
Thank you for your minutes, step down. Mr. Shirley, you may call your next witness.
All right. Well, what do we think about the rock? Have we pounded it enough?
I think we have definitely pounded the rock to death.
Yeah, so does that jury.
Yes.
You call that a dog with the bone.
He could not let go. You know, another thing strategically is we don't have a good nexus for why on an off-road course that one rock gets special spray paint.
Right.
You know, just common sense. I think that's tricky.
Absolutely, especially considering that it's a mountain bike designed for off-road, supposed to be off-course, and now we're focusing on a rock in the forest. Like, does it matter?
Yeah, I think from a technology perspective too, they really could have zoomed in. I was having trouble seeing the rock or appreciating that it was much of a risk. I don't know about the jury.
I agree.
Yeah.
I agree. That's an easy one to do.
Yeah. Wow. We'll see. It's interesting, too. It felt like Tatiana was rushing a little bit. Just as we've been nervous about time, I'm wondering if her pace reflects that as well.
I agree.
I think it probably did, but also it was smart. She didn't need much more than that anyway. Like, a short examination there, I think, worked. I think she got what she needed.
And she had energy.
Yeah.
Kind of bringing us back to energy.
Yeah, it was the kinder side of her, too.
We're all going nuts trying to figure out what the time situation is in there. Fascinated to see how much they actually have left.
Yeah. We've got a couple more witnesses they can call. I think they've only got 2 because Craig said he's not going to call one of them. So we've only got 2 possible.
Are they possibly prepping for closing?
Well, they may be. We've been talking. If so, that's going to take care of their time issues.
Absolutely, yeah.
I thought the tone piece has been so interesting here. Tatiana early in this trial was really very aggressive, and that certainly works, but if that's all you have, not necessarily. And here at the end here, she showed us a different side
You
of
all
her.
are ready before the 5 minutes has elapsed. You may proceed. Just tell me you're ready.
Plaintiff is ready, Your Honor, to reserve any remaining time for rebuttal.
They're going to closing.
Closings.
That was the shortest defense
May
case
it please
ever.
the court?
Yeah.
Closing counsel. When a corporation rushes a product onto the market, failing to ensure that it's safe, they are responsible when a consumer gets hurt. Ladies and gentlemen, that makes sense to us. This is all about accountability here and trust. Because we trust a corporation to put out a safe product, or at least test it. And when they put that product in the market and they fail to test it, fail to give the proper warnings, when they sacrifice safety for sales, they are responsible for that. Because they effectively make us test dummies.
I like it, yeah.
In 2013, Ms. Patterson was sitting in a boardroom.
I think Craig is suffering.
Sitting in that boardroom, she was pondering, thinking how, what, when can make the most money for Texera Cycling. Boom. Change the brakes. Popular, convenient, affordable. They'll buy it. We're marketing it to people who will buy it without question. And that's exactly what happens. They market it. It is purchased. It is purchased by Sarah Day, and she is unknowing about what is lying under her. Unknowing that they put a product out and never tested it. Given fake warnings that are supposed to tell her of the risk associated with this product, and they don't even address it. You are here today because they knew about a problem, they profited from that problem, and thus they must be accountable for that problem. Now today, as I said this afternoon, we have the burden of proof. We have the burden to prove to you by a preponderance of the evidence 3 claims: design defect, marketing defect, and negligence. I told you earlier we embrace that burden because all of the evidence that you have seen today supports the conclusion that the bike was designed defectively, marketed defectively, and they were unreasonable to do so. Now soon, Judge Lynn is going to send you back to that jury room to deliberate. I want to walk through the jury questions with you that you're going to see. I want to walk through them with you so that we can agree, based upon the evidence that you've seen today, when a corporation rushes a product onto the market and makes consumers test dummies, they must be responsible. So let's turn to the first question. Was Texera Cycling Corporation's defective design a producing cause of Sarah Day's injuries? There are 3 elements you're going to have to evaluate here. And thankfully, you're going to hear and see jury instructions, the law that you can apply to the facts you've heard today. You'll read those and hear those, and you'll see that there are 3 key elements. Was the product unreasonably dangerous? Was there a safer alternative design? And was that a causation element to her injuries? Were they a substantial factor in causing her injuries? Let's start with the first one. Was the design unreasonably dangerous? Well, they didn't give you anybody to tell you it wasn't, but we certainly gave you someone to tell you that it was. An engineering expert. A man who was able to describe to you velocity, forces, changes, pressure, everything that goes into how to make a bike. He told you that this thing right here, this thing is not on its own dangerous, but when you add a disc brake, the game changes. When you add a disc brake that is applying constant pressure right here on this little pin that's supposed to hold a wheel, it can migrate down. And see, they didn't talk to you about axle migration today. They didn't want to address that because in their minds, apparently, it must have always stayed up here. But when I was listening to that theory, members of the jury, that just didn't make quite too much sense because if it stayed in the proper place that it was supposed to stay the entire time, if it did what it was supposed to do the entire time, then Ms. Day wouldn't be here today. They couldn't get the expert to agree with anything that they asked because they just didn't have the science to support their theory. Certainly it migrated. He told you so. He told you why it migrated. And he told you that when it migrates, if somebody simply riding a bike hits their brake and it's down here, that's what happens. That's the bike wheel falling out from under Miss Day, causing her bike to go downward as she described, and then everything went black. So yes, the product was unreasonably dangerous, and yes, members of the jury, there was a safer alternative design because they were already making one. Close for it. They were already doing that. January 26, 2016, they started making this sucker right here. And they profited from this one too. They were making this several months before Miss Day suffered her injuries. Several months. And they got up here and tried to tell you that the open fork design, the U shape that has a hole at the bottom, is the safest option? Well, that's just nonsensical. That's illogical. That can't even be believed because you see a safer option right before your eyes. So then you're asked about the causation. They got up here talking about volunteers and cones and signs and instructions in a manual because they didn't want to talk about the bike. But it's about the bike. Because no matter how many volunteers you have outside, no matter how many cones you put up, no matter what sticker, what sign, what bathroom, what person is standing at the transition area, if a bike is about to break, it's going to break. And see, Justin Stewart said that. Volunteer can stand right here and say, hey, whoa, slow down, but if the bike is already cracking, bang. Cone can be right there, somebody can hit the brakes as they're supposed to and make a turn, bike is already breaking, falling. They didn't give you an alternative explanation for that. They didn't. We gave you an explanation. We gave you an expert. So when you get to this question, the only answer is yes. So turning to the second question. Was Texera Cycling Corporation's marketing defective and causing Sarah Day's injuries? Now, a marketing defect has a few more elements. When you look at the jury instructions, it'll tell you that you have to evaluate whether the product was inherently risky, rendering it unreasonably dangerous, whether that product was just put on the market even though they knew it was dangerous, whether there was a failure to give warning and instructions, and if that failure to give warning and instructions caused her injuries. Now, when we were talking about those things, we looked at an advertisement. I want to pull that advertisement back up because, members of the jury, this was very interesting to me today. When Miss Patterson was on this stand, I asked her about this advertisement. I repeatedly asked her if this is what she marketed to people. And then I asked her about this warning they gave. I want to pull up the warning next to the advertisement. Now, the warning they're saying they gave said, do not use for a free ride. That looks pretty free to me. Do not use for a downhill. Is he going downhill to you? Do not use for a dirt jumper. That's dirt. Do not use for any hard riding. That's a mountain. And I saw your faces when I asked her this question, is a mountain hard? And she said no. She got on this stand and told you a mountain must be soft and squishy like a marshmallow. She wanted to avoid everything that she had to admit because she knows she messed up. She knows that marketing a bike like that and then saying you can only use it for leisure cross country is unclear. And that's the question here. Are the warnings and instructions inadequate enough to make them unclear and unsafe? And this is clearly unclear. And then our professor got on the stand and told you that they were unsafe because they never told the consumers what the real risk was. That thing says if you use the fork improperly, you can have personal injury. Well, first of all, there are two problems with that. It assumes that there will be improper use. It does not address if somebody uses it properly. It doesn't say if you do everything right, something can still go wrong. That would be a warning. That would be a proper warning. To tell someone riding a bike fast down the street that your bike may pop out if you do everything right. Secondly, it only tells somebody they can suffer personal injury. This is not a child riding down around their neighborhood, falling off the bike with a scrape of the knee. This is not that. The risk is much higher. They marketed a mountain bike. If somebody is on a mountain and the fork breaks under them, they can suffer serious injury or death. That's what other bike manufacturers warn about. It's a mountain bike, not a leisure cross-country bike, not a scooter, not a tricycle. It's a mountain bike. And as much as they want to avoid that, they can. So when you get to the marketing defect, when you get back there with that evidence, the only answer is yes, because they didn't give you any evidence to the contrary. Then you'll be asked to evaluate the negligence of Texera Cycling. And there are three elements. You'll be asked if Texera Cycling breached their duty of care, if that was a producing cause, and if it caused her injuries.
Just the verdict sheet, right?
Now let's talk about this first element. That simply means that the bike manufacturer did not act reasonably. That the actions that they took were unreasonable for a bike manufacturer. This is simple, members of the jury. Would a bike manufacturer put a bike out without testing it? Is that the world we live in, where corporations can put products into the market and not test them to see if they're safe, and we become the test dummies? Is that okay? Is that reasonable? In fact, Ms. Patterson got on the stand, and I really want to make sure I get her words right. She said it's the industry standard not to test bikes. It's the industry standard to put a product out and not test it? Whew. I get that's the industry standard at Texera Cycling because that's why we're here today, but we know that's not true. We know people don't put products out and not test them, or everyone will be dead. That's illogical. So did they breach their duty of care? Absolutely. And did that breach cause her injuries? 100%, because all she was doing was using the bike like anybody else would. In fact, she was using it in a safer manner than what they marketed it to be used for. So yes, members of the jury, they were negligent. The only answer based upon the evidence you've heard is yes. Now, after you answer that question, we shift. Because see, they brought some affirmative defenses. They didn't want to talk about those this morning. And with those affirmative defenses, they carry the burden. Here at these affirmative defenses, they have to prove to you by a preponderance of the evidence that it's more likely than not that Sarah Day proximately caused her injuries. What evidence did they give you to support that? None. Zero. Nothing. We put an expert on that stand. He told you he evaluated her actions, her speed, her weight, the weight of the bike, what she was doing. He did all the calculations and said it didn't matter how fast she was going. It didn't matter the angle she was going. The bike was going to give out the very next moment she hit the brake. That's what he said. They got up here and told you if Miss Day was riding a little safer, if Miss Day was doing XYZ differently, if she wasn't trying to get in that dirt trail, if she didn't sign up for this race, if she didn't use a bike the way you're supposed to use a bike, if she didn't just ride her bike on a street like they suggested that she do, and then turn onto a dirt road, they got up here and blamed a paraplegic woman for their bike falling apart. And they didn't even have any evidence to support it. So when you get here, because they gave you nothing, the answer is no. So then you turn to the fifth question. Did the negligence, if any, of American Triathlon Association proximately cause Sarah Day's injuries? That's where they spent all their time today, talking about volunteers, cones, signs, how the course was set up. But they had to agree with some things today, and I'm sure you did too. If a bike is defective and it's going to fall out from under you, a volunteer can't stop that. If a bike has become unseated from the bearing low and it's fallen to the weakest point on the bike, a cone can't stop that. In fact, they said that course was dangerous, but it's not as dangerous as what they marketed. That course is on the street. Went from the sidewalk to the street to dirt. To dirt. And they're telling you that's inherently unsafe because she had to go past a rock? And in fact, you didn't hear anything from Miss Day that said she hit a rock? They were making wild assumptions today. Nobody supported that. She just said she heard a metallic sound and then everything went black. They're talking about rocks. They're telling you this case is about rocks, cones, volunteers, because they don't want to talk about their product. Make them answer that question for you. Make them tell you why that's the safest bike, even though everything today pointed to the contrary. When you get to this question, the only answer is no, because Jensen Seward sat on this stand and agreed with me that was a safe course. It's been here in Waco for a long time. And she signed up for it knowing how it was going to go. She prepared. The only answer is no. Now, after you answer all these questions, you have to shift down. And here, members of the jury, it's going to be the difficult part. You have to decide how you're going to apportion fault in a numerical percentage between Texera Cycling, American Triathlon, and Sarah Day. Well, now, here. Since they didn't give you any evidence about Sarah's negligence, we can go ahead and cross that one out. Because they had the burden to prove that to you today, and they didn't give you anything. So now we're left with two, Texera Cycling and American Triathlon. I want to refer back to Ms. Patterson's words. Because see, I think that's the best way we can know who to blame here. She said there was a change to the bike, to the Top Gun 12, to improve the safety. She got on this thing and said they changed to the 12, a new addition that she made very clear, to improve the safety, because it wasn't the safest. It wasn't. They literally sent her outside with a death trap and didn't care. Members of the jury, when you're apportioning fault here, remember the questions that I asked Jensen Stewart. Remember what we've talked about all day. When a corporation rushes a product onto the market and fails to make it safe, they are responsible when consumers get hurt. Because not a cone, not a volunteer, not a warning sign, not a water bottle can prevent a defective bike from breaking up under a person. When you get here, you're going to apportion 100% of the fault to Texera Cycling Corporation. You're going to hold them liable for a defect that they knew about, profited from, and blatantly disregarded. Now look, members of the jury, we are not saying they have to put an airbag on a bike. We are simply saying that they should have taken her bike design from this to this, from this thing they were making to another thing that they were already making. It's that simple. It's that simple because that's their responsibility. That's the trust we put in a corporation. They cannot simply rush a product onto the market, fail to test it, give proper warning, sacrifice safety for sales, and try to hide their hand. Thank you.
Thank you. How much time is remaining? All right, you have 4.5 minutes left for your rebuttal, counsel.
You're on the screen then.
That was a good closing argument. I thought she really hit a lot of the notes right. What did you think?
I think she did a great job moving through the verdict form, answering those questions. It was an efficient use of whatever time is remaining.
And responsive to what actually happened in the trial.
I thought it was good.
Picked up a lot of it, momentum right at the end there. I really liked the finish.
Yeah, it's going to be interesting to see how Craig comes at that, if he can regain the nice guy that was so effective early on.
Right.
Here we go.
Like I said at the beginning of this trial, this was a case about a dangerous design defect. But it wasn't about the dangerous design defect in the Texera Top Gun 10, because there was no dangerous design defect in that bike. It's about the design defect in the course that the American Triathlon Association voluntarily put on for competitors and then failed to provide them with any safety measures, warnings, or instructions. This was a design defect. He had the option. Mr. Stewart had the option to make that course go any route that he wanted to. He chose to send those riders on that root canal trail without giving them a warning to slow down. Now, as much as the Plaintiffs' Counsel wants to put a burden on us, we are not required to disprove anything about their claims. In fact, they have to prove every single element of the design defect, every element of the marketing defect, and every element of negligence. Now, the judge is going to tell you that a design defect, in order for them to prove their claims, they had to show three things. They had to show that the product was unreasonably dangerous, that there was a safer alternative design available, and that the defective product, if any, was a producing cause to Ms. Day's injuries. Now, what the judge is also going to tell you is that when you're determining whether a product is unreasonably dangerous, you can consider multiple factors when weighing the risk versus the utility. You see, in this jurisdiction, you don't just look at a product and say, that one looks safer than that one, so that one had to be unreasonably dangerous. No, there are factors you have to consider. The product is only unreasonably dangerous if its risk outweighs its utility. It's a balancing scale. So I want to go through some of those factors that the judge is going to give you when deciding whether it's unreasonably dangerous. The first factor is weighing the utility or the usefulness of the product against the likelihood of the injury. Now, we know how useful this product was to Ms. Day and to every other person that bought a Top Gun 10 model. She told you the reason she bought the bike in the first place was for the open fork design, the quick release system, and the disc brakes. She told you that she needed a bike that would be easier to transport, easier to fix, easier to store, easier to change the tire. That makes that quick release system useful. That's the utility of just that system alone. But the disc brake itself, as Ms. Patterson told us, also carries its own usefulness. The disc brake is a better brake. It provides more stopping power for a smoother stop, and it works in all conditions, rain, sleet, or snow. That's the usefulness of the disc brake. You take that usefulness of the disc brake, the usefulness of the open feature, that's why the product is the top seller. That's why people are buying the product. You weigh that against the risk, the likelihood of the risk. Now, we heard from the professor on the stand today about how unlikely it was that that open fork design was going to break. Because it's not just every time you clutch on the brakes, the open fork design is going to shatter. That's not what happens. The brakes could cause the axle to migrate down. Not that it's going to, not that it will, but that it could in certain circumstances. And then it has the possibility to break. Not that it's going to break, not that it will break, but it could. That makes that risk of that axle sliding down and breaking the open fork design low when you weigh it against why people are buying that open fork design. Your utility's up here when the likelihood of the risk is way out in the future when you have to do coulds, maybes, cans, who knows. And that's just the first factor you can consider in deciding a reasonably dangerous. But the second factor you can consider that the judge is going to instruct you on is that whether the plaintiff was aware of any warnings. If the plaintiff is aware of any warnings, that lowers the risk and increases the utility. And we know that she was warned. That warning label that we saw at trial all day today was on the open fork design itself, slapped right on the design. It's on the bike right there. And we know Ms. Day read this warning. And how do we know that? Because she told you that she changed that tire hundreds of times. To change the tire, you have to be looking down at the fork. You're going to see that highlighter yellow warning sign on that black fork. That's hundreds of times she could have seen that this bike is only for leisure cross country. Hundreds of times she could have seen that she didn't need to dirt jump or hard ride. Hundreds of times she could have seen that if she improperly used the bike, it could cause fork failure and personal injury. What other warnings did Ms. Day want? Because not only did she have those, she had the warnings in the owner's manual that told her about the importance of clamping down the lever to secure the axle into the open fork design. Two different warnings about two different aspects of the bike in two different places. There was a warning and the plaintiff was aware of it, which means the risk goes down, the utility goes up. That's why this product is not unreasonably dangerous. And that's the standard here. We cannot hold companies in our country to a perfect standard. Otherwise, no companies would exist. When we go to buy a product, we look for a reasonably safe product. Not a perfect product because it can't be made. This product was not unreasonably dangerous because the usefulness of the quick release design, the usefulness of the disc brakes, the notice of warnings the appearance of warnings all outweighed the distant unlikeliness of that axle slipping out. So you don't have to worry about whether there is a safer design on the market because the plaintiff cannot overcome that first element of unreasonably dangerous. And the judge is going to tell you that they can't prove that very first element, the entire claim fails. But they also had to prove to you that there was a marketing defect. And just listen to what the judge instructs you. It's going to be a long list of elements. And what it is, one of the elements that I want to focus on is that there has to be a failure to warn, but the failure to warn has to make the product unreasonably dangerous. It's not that the product's unreasonably dangerous by itself. It's not that there's a failure to warn by itself. They have to coexist. That's the hurdle that this plaintiff has to overcome. We just talked about that this plaintiff was warned hundreds of times that this bike was not meant to be used on a hard ride, dirt jumping, like going over the ramp of a root canal. It's not designed for that, and she was warned about that. And she was warned what would happen if she improperly used it. So they failed to prove their marketing defect because there was a warning and because this product was reasonably safe. Which brings us to their negligence claim. They want you to believe that we failed to exercise ordinary care. And now plaintiff's counsel just got up here and was talking about Ms. Patterson on the stand today and was talking about a standard, that the standard is not to test your bikes. That is not what Ms. Patterson said. No matter how bad they want you to believe it, that is not what she said. She said, is it an industry standard to test your products before putting them on the market? And I asked her, when she put the disc brake on the Texera Top Gun 10, if that bike itself was already on the market. She said yes. That all she did was switch out the disc brake for the rim brake. That's it. That's the only thing she changed. She told you that Nexus ran their test. That's the industry standard. They tested the product for safetiness, and it was reasonable for Ms. Day to rely on that, to rely on the statements from Nexus that said, yes, we did test our product. You can go ahead and put the disc brake on there. That is reasonable care. All Texera did was take that disc brake and put it on the existing model that was already at market, already tested, and already being sold to customers. They acted as a reasonably prudent manufacturer would have because they relied on that word from Nexus. The plaintiff failed to prove either one of those claims because our product was reasonably safe and Texera exercised ordinary care. But now we did have a burden to prove two things to you. We had to show you evidence that Ms. Day was negligent and was a substantial factor in her injuries, or her injuries were approximately caused by her injury or her negligence. And two, that the American Triathlon Association did not act reasonably and that they were approximate cause in Ms. Day's injuries. I told you that although it's hard to stand up here and try to put the blame on somebody that's lost so much, that's the hard truth that we have to face today. And it's not that Miss Day was maybe going too fast into the root canal. It's not that she was just flying down the street. But I want you to focus on when I was asking her about the bike staging area before the race when she was installing that mountain bike. Although she didn't really want to admit to it, hundreds of times she told us that she had installed that front wheel onto that bike and she remembers doing it perfectly. Well, hundreds of times before that, she'd never had an accident. But specifically on May 30th, 2016, that's the one day she can't really specifically remember if she clamped that lever all the way down. Which means that if she didn't lock that axle all the way into place, that could have caused the axle to slip and not the disc brake design. If Miss Day did not properly tighten down that clamp, that could have led to the axle sliding down. The axle slid down, based on that negligence, then she was a substantial factor in her own injuries, like it or not. And we know that that is likely the case because we had the professor on the stand today, and he told you how hard it is to clamp that lever down. And he told you that you would notice if that clamp was not all the way down. And she's in here saying that she cannot specifically remember locking it down. If you have to put that much force into something, you're going to remember doing it. And we can all understand why she wants to forget that she didn't do it. That's reasonable to understand that. But that could have been a substantial factor in her injuries. But the majority of the responsibility lies on the ATA. And this is not about whether a volunteer could stop a defective bike. We've already discussed that this is not a defective bike. But it's not about whether a volunteer could stop a product from breaking. It's not about whether a cone would stop a product from breaking or a sign would stop a product from breaking. You know what? It's not even about just having cones on University if the bike portion was a straight shot. It's not about the lack of volunteers on University if the bike part of that triathlon was a straight shot. But when you make your riders go down University without monitoring their speed, letting them go as fast as they want to, and then forcing them to take a hard right turn over a ramp where there's a rock waiting for them at the bottom of the ramp, then you need cones. Then you need barriers. Then you need volunteers. Then you need warnings. Then you need flags. Because the ATA owed a duty to protect their customers from those things, whether Mr. Stewart wanted to admit it or not. They should have marked that rock at the bottom of that drop, as the professor put it, with spray paint, flags, a sign. You remember seeing that picture from 2012? On the right side of the photo, there was a big red arrow telling the riders to go straight. All they had to do was take that big red arrow, lay it on its side so the riders could know to avoid the rock. That's it. They could have had a volunteer at the root canal entrance. They could have had more cones to slow people down. They could have had signs telling people to watch their speed, but they didn't, which means that it allowed Miss Day to enter that root canal at a dangerous speed and then hit that rock. And what's important is Miss Day could have hit that rock,
And he needed to get
that
closer.
could have
Yeah.
been the cause of breaking that open fork design. Hitting that rock at high speeds after going over a ramp could have caused that aluminum to snap. That would have caused Miss Day to fly over her handlebars. That's why ATA is responsible, because they failed to protect their competitors from that foreseeable rock in the middle of a trail causing an injury. They owed a duty to their competitors. They failed to meet that duty. This was a defective design that the American Triathlon Association is responsible for. And you're going to get that verdict form that opposing counsel showed you on the screen a little while ago. So I want to walk through each one of those questions and just show you why the answer is no to the first three and yes to the next 4 and 5. The product was reasonably safe, so the answer to question number 1 is no. The product was reasonably safe, so the answer to question number 2 is no. The product was reasonably safe, so the answer to question number 3 is no. And Miss Day contributed to her injuries, so the answer to number 4 is yes. The ATA contributed to Miss Day's injuries, so the answer to number 5 is yes. That is why the American Triathlon Association and Miss Day are responsible. That's the hard truth about this case. It had nothing to do with the Texera Top Gun 10. It had everything to do with the failure to warn for the ATA. The ATA does not get to make a defectively designed course and just wipe their hands and walk away. They owed a duty, and they failed in their duty. Make them take responsibility for that failure. Thank you.
Thank you, counsel. All right, you have 4.5 minutes left for your rebuttal.
Yes, Your Honor.
Okay, what did y'all think about Craig's closing? Quick comments.
I thought he did a really good job breaking down the law and was thankful he went quickly through the jury for him.
Yeah,
Third trail. In fact, exactly what they said was, this bike wasn't meant to be used to go up a ramp now. Now it's a ramp. This mountain bike, marketed as a mountain bike. This isn't a case about risk versus utility, but if it really was, the risk is that she never is going to walk again. The utility is dollar signs in their pockets. And you know what? I can agree with opposing counsel about one thing, the logic behind his theory he just told you. He said if the design course is wrong, they're liable. Right, because if you're a corporation and you design something defectively, you're responsible. Just like they're responsible because they designed a bike defectively, marketed it defectively, and they were unreasonable to do so. His logic is great. The person is wrong. Because they didn't give you any evidence to support what he's saying right now. He keeps talking about a rock. But Ms. Day was on this stand. She never said that she hit a rock. Never. Never. When you go back in that jury room, you're not going to see anything that says that. They're giving you guesses, conjectures, speculations, estimations, even hypotheses. We gave you cold, hard facts. That when a corporation rushes a product onto the market and they fail to make it safe, they are responsible when consumers get hurt because they make them test dummies. Don't let the defendant hide their hand. Hold them liable. Thank you.
Thank you, counsel. Ladies and gentlemen of the jury, you are deemed to have received the court's charge. You may now retire to deliberate upon your verdict. All rise for the jury, please.
All right, so we've got the trial in the can. Now the jury's deliberating. You know, what would it be to have a trial without asking a bunch of trial lawyers their opinion? So let's go around the table. Who do you think won it and why? Sarah, let's start with you.
I think Tatiana took it. Craig did a lot to climb back in that speech. His closing was wonderful, but I think with the evidence and the examinations, I'd give it to her.
Susan.
I'm a little more torn. I think he came on strong at the end. I think his closing had a big impact, and I think her rebuttal was a little rough. So I'm maybe going with Craig.
All right. Liz.
Am I allowed to plead the fifth because I'm friends with both coaches?
No.
I think that hands down Craig won the score on the speeches, but I think Tatiana might ultimately pull it out given the ballot and the way that it is, because I think that her performance on the examination of witnesses and potentially the evidence may have been a bit more strong. Sorry, Judge, I gotta go Team Tatiana.
What do you think?
I'm with Liz on this one. I think Craig wins the openings and the closings, like with the structure and the delivery and the reasonableness, and I think Tatiana gets everything in between. The first cross of the defendant was a little long, right? But there were some very, very powerful points in there, and I think she wins on the evidence. Like there were some objections that we should have seen from Craig that we never saw at all.
Spencer.
And I am impressively bad at predictions of all types, but especially this type of prediction. So
your paycheck out of this rides on it. So let me just up the stakes.
Okay.
Right?
I
We need to talk about that contract later.
I think that it's probably really a tribute to the Top Gun ballot that this is really interesting and difficult to sort of figure out. Based on the ballot, I think that I got to go with Tatiana, really for the same reason that Julia just said. But there was a momentum there that Craig had at the end, which on a different ballot might change the numbers. But I think Tatiana.
Yeah.
They both did a great job.
You know, I think it was really interesting. I was so glad for Craig that he pulled some momentum back. Because, beyond just this trial itself, you want to walk out of this feeling good about your performance.
Well,
and I felt that Craig got rattled with some of the examinations. And to me, it is such a testament to him and his resilience that he pulled out and gave a great closing argument. And I don't know about y'all, I felt like Tatiana, right at the end, was a little rattled. She was fast, she was a little shrill. I think she didn't see that part of Craig coming. So I think it's going to be a tough ballot. While our judges are deliberating, let's give some more comments.
Yeah, so I think, talking about the rebuttal, for example, that you just did, I mean, it felt like the substance, she really did drop the mic. I mean, Julia, that was your reference. But I do think that the presentation, that style difference between that rebuttal and Craig's closing, which he's always the voice of reason, extremely passionate in a right manner, it's just such a difference in styles there.
Well, and I think that's a great point, because while we have this ballot for the judges, at some point you're appealing to style, and they had very distinctive style. It'll be interesting to see, we talked earlier about how likable Craig is. Did that come back enough? Did you feel like Tatiana connected with the jury with her style? What do y'all think about that?
So I think she absolutely came back around in the second half of the trial. That was the bold move of calling an adverse witness as the very first witness, because it puts you on a different edge, a different level. So we're going to be testing with that witness on cross. But then she was able to come back around. And then the concern was in the rebuttal, like when Susan mentioned, like she just kind of lost it there on the end. But she was able to show a lot of variation with depth and tone, sure.
I thought emotionally that Tatiana stayed in a closer band of consistency, and this kind of comes back to us talking about Craig a moment ago. But in the middle, it got hard. It got real hard out there for him, and that's an interesting thing, right? This is something that coaches, students, trial lawyers, everybody deals with. But to maintain your own tone the whole time, it's really difficult. If you stray from it, does the jury penalize you? Can you gain that back? Get a little bit of trust back? It's really hard.
Yeah, and we know it is really true, and you can see it even in a mock round like this.
Yeah. Well, and I think that's where my hesitation is, even though I ultimately said Team Tatiana. I think that Craig wins in the likability battle, but then again, I don't think we had the same perspective that a jury does. And so I think sitting there and seeing it and being able to gauge the credibility of the witnesses and the attorneys and the likability of them, it's a different ballgame when you're sitting in the jury box.
Okay, so we're going to see how well we do at prognosticating, because I think we have a winner. Let's go back to the courtroom and see who that is.
I'm nervous.
I'm sure
they are too, I think.
Right, it's like a real first one.
Be seated, please. Well, that was a ton of fun for me. I know it's a lot of work, and I just commend you all very much on what you did. I'm going to put you out of your misery and announce the winner, and then I have just a few things I want to say to you. Ms. Terry, you are the winner in the final round. Congratulations to you. Ms. Terry, I'm going to ask you if you would introduce your co-counsel and tell us what school you're from.
Yes, Your Honor. My co-counsel is Hannah Wallace. She is my tried and true best friend trial team partner. We've been doing this 2 years. And I am from Campbell University School of Law. I was coached by Professor Dan Tilley up there.
All right.
He's not paying attention right now.
Very good. Mr. Shirley, congratulations. A very fine job by you. I wish I could divide the 10,000 in half, but I think the tagline is no points for second place.
I appreciate it.
But if I had a couple extra bucks, I would put it in for you,
Thank
Mr.
you.
Shirley. Very fine job. If you would introduce your co-counsel and tell us what school you're from as well.
Absolutely. Yes, I'm here with my co-counsel, Ms. Stephanie Gushlaw, and we are from Cumberland School of Law in Birmingham, Alabama.
All right, thank you very much. Well, I mean sincerely what I said. It's a long drive down from Dallas to Waco, and it was well worth making. That was a real treat. It is sort of trite to say, but I will tell you I'm in trial now. Don't tell the lawyers in my case that I said this, but I'll take you to any day. Really a great job. I just don't know how you could put it all together on the notice that you had. It was really great. And my mother I brought with me, and I could tell, that's my mother right there, Nelda Golden. She's seen a lot of trials. Wasn't that really good, Mom? Yes. So unfortunately, I have to fly. I've got to get out of here for an event I have back in Dallas, so I won't be able to stay and visit with all of you, but I'm very happy for you all to send me an email. Please do, and then I'll email you back any additional comments that I had. But it was an extraordinary effort, really a wonderful job. I appreciate it. If I could have lawyering like that every day of the week, my job would be a whole lot more fun. So thank you all very much, and I'm delighted to have an opportunity to have been here with you. Jury, thank you very much for your good work.
Thank y'all.
All right, everybody, not a surprising winner. I think that's what our panel had predicted. And off for Top Gun 10.
Big
Spencer.
Spence from Berkeley.
It's fun to get to wear the glasses, right?
You know what? Depends on how comfortable you are.
Well, we'll find out. No, it was a great round to watch, and so much fun to see both these folks compete. And it's hard to pick a winner, hard to have a winner and have a not winner, as I would say. But I just really loved watching both of them.
Me? Are you sure? I'm
Yeah,
just checking.
I'm sure. We're going in
So
order.
listen, I mean, great experience. Both of the advocates, it was fantastic to have our young advocates from Stetson here to be able to watch them and learn from this experience. But they both did a phenomenal job. Campbell and Cumberland have incredible programs, and Baylor puts on an amazing competition. So it's been incredible.
Great.
I have to say, Craig, hold your head up high, buddy. You did an awesome job. Even though you didn't win the whole thing, you really did an awesome job. And to Tatiana, congratulations to you. At American, we use the Top Gun video every year for teaching purposes, and I can't wait for my students to be able to learn from the excellent job that you just did. I'm off to bed now.
Well, I got to agree. My advocates from Temple are going to go get some sleep tonight, I think. But have learned a lot from being here, as we always do. Baylor puts on a great competition, and this final round and the advocacy we saw from both of them is a testament to that. So, and just thank you, Baylor, and thanks for inviting us. This was great fun to get to do.
Agreed.
Nobody does it better than Baylor, for sure. But a shout out to the two coaches, too, because we have some really well-coached teams in this tournament, and those were two examples of outstanding coaching.
This has been a great final round. Thank you for joining us. Thank you so much, colleagues, for our panel. This has been
was so
great
fun.
fun.
Yes, absolutely.
Next year, we're going to add a calorie meter because we have been snacking like this was a movie. So,
Anyway,
anyway, see you and goodbye from Top Gun 10.